sister's boyfriend.
Oh.
This is her.
Somebody she knows.
Yeah, she's not gonna give anything illegal. She's like, fine.
Because he wouldn't use me to do that.
Yeah,
Then he was
yeah,
doing
because
that.
he's yeah, he's like 18.
Well,
Did she? Was she looking at? She said her PayPal. She like.
All right, let's get started. Oops. Yeah, Ms. Rivers is working her way into the building, so we won't like jump right into a plea or a surprise trial. But we can call a calendar, figure out who's here, who's not, and what we're gonna do. This is a final plea calendar. If you're on this calendar and you don't resolve your case today, then I will see you no later than August 7th when we call the August trial calendar. So that's the trial calendar onto which these cases fall, I believe. Position 1 is Melvin Sampson.
Good morning, Your Honor. Michelle Ruff for Mr. Sampson.
Hi, Ms. Ruff. How are you doing?
I'm well, thank you. How are you?
All right. Have you had any contact with your client recently?
Yes, this morning twice. He was parking when I last spoke to him, so he should be in the courtroom more momentarily.
Okay, we will hold for his report, but I interrupted you. You were going to add something?
I would like to speak with the ADA in a breakout room if that's going to be possible today.
Sure. Let's get Mr. Sampson here first. Ms. Davis, is this your case?
yes, Judge, it is.
Okay, yep, we'll figure out a way for Ms. Davis. It probably would be just a phone call to you because she could retreat to the jury room and then call you at a number that you want to, if you want to send her, well, she's not on. You can send me a good number through the Zoom chat function and I can share that with Ms. Davis and she can give you a call, assuming Mr. Sampson gets here.
All right, thank you, Judge.
Thank you. Ms. Hamilton, positions 2 and 3. Good morning.
She is on the Zoom call under the name Leah.
All right. Good morning, Ms. Hamilton.
Good morning, Judge.
How you been?
I'm fine.
Where are you? I like that little kitchen.
I'm in the kitchen. I'm actually in the kitchen. I'm sorry.
Yeah, but like, is that your spot?
No, it's not my house. No. It's
Okay.
a family member.
Okay. Well, good. Ms. Wood, what are we doing today with Ms. Hamilton's cases?
But we're trying to work them out. If
Okay.
she could fall off of the Zoom call, I'm gonna call her after the call.
Okay. Ms. Hamilton, do you have your phone with you? You know, I mean, you don't need it like right in your hands, but is your phone nearby?
Yeah, I don't have a phone actually, so like I would have to use the phone. Hold on, give me a second.
Okay. I just need a good phone number for Ms. Wood to call you.
Okay.
Oh, wait.
Okay.
She's back. Yes, ma'am.
It's 470.
470. You writing this down?
998
998
6234.
6234. All right. Ms. Wood's going to give you a call in a few minutes to see if we can sort out both your cases and get you on your way. Okay?
Okay.
It's nice seeing you.
Nice seeing you too, Judge.
All right. Make sure you get back on, but Ms. Wood will call you in a little bit.
So you want me to go out?
Should she drop off now? Yeah, you can drop off now. Ms. Wood will call you and give you instructions, okay?
Okay, yes, sir.
Bye.
All right.
Mr. Cassell's case has been resolved, so position 5 is Arthur Burke. Oh, he's in Cobb County. Is he in Cobb County as in he's here?
Call 5:30.
Oh,
Can we not?
yeah. No, that's great. So since you're here, I've heard now 3 different answers about, first of all, is he our inmate or is he's in Cobb and they just, because I think he has court soon. But when our folks who are up at Cobb, so we do have Zoom. Okay, that's what I thought, because I reached out to a Deja and I said, I didn't hear anything change, but someone was telling her like, oh, we don't have enough people anymore. Okay, so it's still happening. Once I see Cobb on, we'll take care of Mr. Burke. Thank you so much. Surprising, she just popped like a genie. Okay. No, exactly. That's the difference. That's what she was explaining. So Cobb's doing us a solid by getting them on. What are we doing with Mr. Burke?
Possibly the plea judge.
Okay, TBD. All right. Quantavious Terrell. Come back to that. Antoine Owens should be in custody. Oh, this case. That's why you're here.
Yes, Your Honor.
Good morning. I don't see Mr. Kraft on.
Travis has a leave.
Oh, okay.
I was aware of, but I don't know if anybody else was in the house.
Well, how about, on his behalf, you mean?
Yes.
Well, let's get the co-defendants. How many of the defendants are juveniles?
Just Mr. Owens.
Just Mr. Owens. Okay. Mr. Palmer, that's your client, Ms. Rios.
Yes, sir.
What are we doing today?
Final plea hearing.
We'll just have that quick conversation. Okay. Is Mr. Palmer here? All right. And then, oh, Palmer's not here. Oh, okay. Well, his lawyer's not here either, so we're okay. I don't know that Mr. Kraft will end up being here, but I can at least tell Mr. Owens what's going on. And then Amori Williams, that's Ms. Cabrera's client. So my guess is we'll just move all 3 of these to the trial calendar, preserving the final plea rights, but we can at least interact with Mr. Palmer. So we'll do that in a second. Sharda Rusa. Oh, there she is.
Yes. Hey.
Hey, how are you?
Good.
Good. So any way you can get down to court, or tell me where I don't need your street address. Where are you calling from?
I'm calling from 509 Boulevard. She told me to do it. I can do it through Zoom. Miss
Oh.
Woods.
Okay. What are we doing today, Ms. Wood? How do you pronounce your last name, ma'am?
Russell.
Russa. What are we doing today with Ms. Russa's case?
Possibly the plea judge.
Possibly a plea. All right. You should talk with Ms. Simpson to make sure there's not a hiccup with all that. Should we just have Ms. Russa stay on the call and you'll talk with Ms. Davis?
Yes.
All right, Ms. Russa, if you'll stay on the call, we'll circle back to you once Ms. Wood has had a chance to talk to the prosecutor, okay? You went on mute.
Okay.
Are you able to sit tight?
Yeah.
Okay, great. Thank you. Mr. Horn already pled. I don't know if Rogers and Mender, are they not coming over? Good. Okay. That will be a plea hopefully on Tuesday of next week. Next week will be a little bumpy. Jason Rhodes. Mr. Rhodes is here. Good morning, sir.
Good morning.
Ms. Wood, what are we doing today with Mr. Rhodes?
I'm speaking with the judge or,
All right. And finally, we've got Ms. Stone. Is Ms. Stone here? How do you pronounce your first name? Garyana Stone. She is here. Ms. Rios?
Yeah, after that, we can keep her final plea rights intact. I have some information that might be exonerating for her case. I had to wait for our office to conflict off another case before I felt comfortable providing that information, because it involves another one of our clients, but then we just get the conflict. So I'm asking for more time to get that information to the state.
So keep Ms. Stone's case going forward. It will go onto the August trial calendar, but we'd preserve her final plea rights.
Yes.
All right. Okay. I mean, I guess that doesn't compromise anything for the state. I read the affidavit last night just because I was curious. We don't get theft by extortion all that often, so I'm not quite sure what would cut Ms. Stone out of it completely. But you've worked magic before, so maybe you'll get something that cuts her out of it completely. Ms. Davis, any issue with just rolling this to the trial calendar?
No, Your Honor.
All right, so Ms. Stone, it sounds like Ms. Rios is gonna continue to work to make your case less and less serious for you. Let me just check one thing about your bond. This is an old case. Okay, you were just supposed to stay away from an address and from a guy. That should be easy enough while you're on bond. Do you have any questions about anything? No? Ms. Rios, do you want to speak with Ms. Stone before she goes? Okay. Ms. Stone, I will see you at the latest on August 7th when we call the trial calendar. Before then, it sounds like Ms. Rios will be getting some information to the prosecutor that may cause us to get together sooner to talk about your case. Do you have good contact information for Ms. Rios? Okay, and Ms. Rios, you have good contact information for Ms. Stone?
Yes, sir.
All right. Well, if you don't have any questions, Ms. Stone, I appreciate you being here, what you needed to do, and we'll just move your case to the trial calendar. You want to talk with Ms. Rios? Sure. We're about done calling the calendar, and then I'm going to take a break, and the lawyers are going to circulate. So why don't you stay right there, and she'll talk with you before you head out. All right. So that was it, other than Mr. Oliver. I think I see you back there. Ms. Wood, you're 0 to 4, or that's Ms. Rios?
I'm here.
Elijah Oliver, 25 SC 001734, not on any calendar. Don't flip through your papers. He has a bench warrant. He came in late last week with his mom, who I think is here again. Nope. He came in with his mom last time and someone else, but either way, they explained that the apartment complex where they still live, the address in the Odyssey is still a good address. It's one of those apartment complexes where there's a centralized mailbox with 50 mailboxes, and the apartment operator knocked the whole thing down, said we're going to put up a new one, but for about a month and a half, no one could get mail. They went to the post office, and the post office says, no, we're taking it to the apartment complex. Who knows where it went? He missed court, is what he's told me. But he walked in on his own with family. I can't remember when it was, Thursday or Friday of last week. By then we had dispersed, so I didn't have a prosecutor to say, I'm okay setting aside the bench warrant. I didn't have a defense attorney to say you should set it aside. We didn't engage about the facts of the case. He just told me who he was and what was going on. I looked at the charges. I had Deputy Gordon cover his ears, and I said, you should leave the courtroom, stay out of trouble between now and Tuesday morning at 9 a.m. because there is a warrant for you. And he quietly left the courtroom and stayed out of trouble. And he's back again, coming on his own. So if you would talk with Ms. Davis about it, all we need to work through is, are we setting aside the bench warrant? It could be, looking at the charges, resolvable, but I think it's way early. And so probably what he missed was plea and arraignment. And so I then just need to know if you're going to waive arraignment for him, and we'll get Mr. Oliver's case moving along. So that is not regularly scheduled. Thank you for dealing with him. Anyone else come in and not hear their name called? You, sir, are?
Melvin Sampson.
Melvin Sampson. Excellent. Your lawyer is on Zoom, and the prosecutor is going to call her in a minute to talk about your case. So I need you to sit tight there. Anyone else? Why are you back here? Just in case? Okay, your case got dismissed.
Okay.
So it's all right. It never better be safe than sorry. You are on the calendar, but because the state dismissed it, I already announced that we weren't going forward with that. So good seeing you. Stay out of trouble, and you can be on your way. That's Mr. Cassell, so people know. But all right, take care. All right, so this is last call for Quantavious Terrell. We will add to his list of warrants. And Ms. Rosa is on the call. Rogers Mender will be a plea. And I'm not remembering. Jason Rhodes is here. Jason Rhodes is in the front row. Okay, that's it. I will come back out once you guys are ready to do final plea hearing, plea, whatever it is. Mr. Abate, you are here. Why don't we do Mr. Palmer real quickly? Because then you're welcome to stay. You can get out of here because I think that's the only one of the three defendants who's going to have a lawyer here today.
Yes, Your Honor.
Excuse me, Judge. Did you see my phone number in the chat?
I did. I wrote it down on a card right here. So I'm going to give that to Ms. Davis. Once we're going to handle one defendant here, and then we will take a break, and you'll get a call. Hey.
Thank you.
Mr. Palmer can come right up to the podium. Ms. Rivers, your timing was perfect. I need to know, well, when you fire up, we got Mr. Palmer here. Need to get that on the record. Mr. Palmer, we're going to talk real briefly about your case and what's next. I just need Ms. Rivers' system to be up so she can take down the conversation.
You man.
Should I ask? Sure. Okay. Ms. Davis, while the system is firing up this afternoon, we have a probation revocation hearing. That's one where Mr. Glenn, who is Mr. Lemons's lawyer, had said, I want an evidentiary hearing. You good to go on that? Or have you and Mr. Glenn been talking and it's going to be something other than an evidentiary hearing?
We've been talking, but he called me while we were in court, so I don't have an update, but I do have the officer subpoena.
Okay, so you're ready to go, assuming the officers show up. Got it. And I think Mr. Shart's showing up this afternoon to plead. I think the guy's name is, yeah, I mean, it's on the digital calendar. I gotta have a piece of paper. There's just this red bar on the calendar that says Justin Elder. Okay, I don't remember.
Mr. Elder was kind of a bootleg reset from last
Right.
week for a plea.
Yeah.
So I anticipate we emailed on Friday. I didn't believe that he was.
Yeah, and I've got that Mr. Shart, I assume his client, oh, and maybe they're even zooming in, but it's gonna be at 1 o'clock.
Oh, okay.
You good? Okay, let's go on the record. This is 24 SC 006518, State versus Deontay Palmer. Mr. Palmer is in court with Ms. Rios. Mr. Abate represents the state. And Mr. Palmer, today is your final plea date. And all that means is if you were to try to resolve your case today, which would mean if you were to plead guilty, you'd have the right to withdraw your plea if the sentence I gave you was more than what Ms. Rios asked for. After today, you can still enter a plea, and it may be that you and Ms. Rios end up negotiating something with the state. Just you don't get to back out of your plea tomorrow or the next day or a month from now if you don't like the sentence you get. Given that you're charged with murder, this conversation is usually kind of just a formality because unless the state is reducing charges, if you plead guilty to what you're charged with, I have to sentence you to life. And not a lot of people plead to life. Sometimes they do. Actually, unless the state changes some things, it probably be life and then some other years too. But I'm going to find out from Mr. Abate what the offer is right now. And then you're going to tell me I'm not interested in that. I'd rather go to trial, or yep, that's what I want to do. Before I do that though, Ms. Rios, do you feel like you've got all the discovery in the case?
There's some text messages I thought were between the co-defendants that I have been looking through the Dropbox that I can't find.
Okay.
You have them. They're right here. There's a, I guess I'll have to pull them out for you.
Okay.
Okay. It sounds like they were provided, but maybe you haven't been able to bump into them yet. I'm sure Mr. Abate can direct you towards those. More importantly, they clearly exist, and so they'll get to you. It's not we don't have the GBI results, and so we need to delay this. Mr. Abate, if Mr. Palmer wanted to resolve the case today, what is the state's recommendation?
Your Honor, as of today, it's life plus the mandatory 5 that would be suspended.
Okay. So the other count, the armed robbery, would run concurrently with the murder.
That's correct.
Okay. All right. So Mr. Palmer, if you were to plead guilty today, the first big if is that you'd be pleading. You may be advocating your innocence throughout this, and that's fine. But if you were to plead guilty, then the state would recommend, right now, it's the lowest possible sentence you could get based on these charges, which would be a life sentence plus 5 years suspended. Do you understand what the state would recommend?
Yes, sir.
Okay. Ms. Rios actually can't recommend less than that. That's the lowest. So she'd be recommending, yep, judge sentence him to life plus 5 suspended. Is that something you're interested in pursuing today?
No, sir.
Okay, understood. Your case is going to be on our August 7th trial calendar. So I'll make sure Ms. Rios gets these text messages she was talking about. And she'll be talking with you. You'll be back here on August 7th. That won't be the day we do the trial. That'll be another chance to talk about, is this case resolving or not? Your case has some moving parts because you've got 2 co-defendants. And sometimes if one co-defendant pleads, that creates sort of a domino effect. But each defendant decides that on his own. You've got a great lawyer. You and she will be talking about that. And it may be that in August, we try this case. All right? Any questions about anything?
No, sir.
All right, Ms. Rios, anything else on behalf of Mr. Palmer?
No, Your Honor.
All right, we'll see you soon, Mr. Palmer.
Yeah, just,
Oh, one more thing.
just so everybody knows, the only thing that's pending is obviously the ballistic evidence. I have put in a number of calls, so I'll just keep doing that.
Okay, I forgot to ask you. So the one piece of discovery you don't have yet that you'll get to Ms. Rios is the ballistics result. Is this the case where a guy was walking through a cut on the way to the Amazon warehouse, or this was a gun transaction? Gun transaction. Okay. And so ballistics matter because there were a bunch of guns in the mix?
Yes.
Okay.
There was a preliminary analysis done by the APD crime lab through their NIBIN system, and it's useless because they can't testify as experts, but they've sent it to the GBI for verification, and I'll just keep going.
That's where it sits?
Yes.
Okay. All right. Thank you so much. All right, Mr. Palmer, we'll see you soon.
See you soon, my boy.
All right. Why don't we take a break? Did anyone else come in since I called the calendar? Oh, we're good. If someone would please speak with Ms. Stone, because then she'll head out. We've got Mr. Rhodes here. Ms. Russa is on the phone. And Mr. Sampson is now here, but Ms. Davis, I think Ms. Ruff wants to talk with you, and I've got her number right here.
You can look at it right
Phone numbers.
now. So,
Maybe digital number? Because I don't see.
Thank you.
yeah.
Ms. Singleton, you are here in case we end up talking to Mr. Owens?
Yes, Your Honor.
Okay.
I'm thinking probably not if there's no other.
Right. If his lawyer's not here, I'll have him pop out right there, and you're welcome to stay, but it would simply be to explain that I'm moving his case to the trial calendar and preserving his final plea rights.
Yes.
That'll mean to him.
Thank
All
you, Your
right.
Honor.
Thank you.
That's it. Oh,
Yes,
wait,
can I put it on this automatic?
Yeah. Hold on one sec. Let me mute this.
Mr. Sampson, please step out and take my call.
Recognize your attorney or anything? What's up, Sarge? Yeah, he's Fort County.
$427.
All right. Hey, Mr. Burke is on the screen, and Cobb County's doing us a favor by getting him there.
I was told they would give me a number to call, so if they, they're gonna send that via Zoom or just tell us. I'm not-
Okay, we're live now. So, Deputy, who told you this?
Deputy Gordon.
Oh, okay. Is there a way that Mr. Burke's lawyer can talk with him? Is there a phone they call, or what do we do? Or is this it?
She's need to talk to him by herself.
Yeah, yeah, but you know what? We could get her to log on to Zoom in the jury room, and then I'll do it electronically if that's okay. Okay, thanks. Mr. Burke, Ms. Wood is going to log on to Zoom, and then I'll put the two of you into a breakout room, and you can talk about what's going on, okay?
Yes, Your Honor.
You need the bag? You gonna need the bag? Okay. Up to you. Let me see your
All right, looks like Ms. Wood is on. Can you hear me, Ms. Wood?
Yes, Judge.
Great. All right, I'm going to put you and Mr. Burke into a breakout room if I can make this work. Let's see.
Thank you.
Slide manually, create. And Lacey Wood. Go. All right, I think they're in. 1, 2.
Oh, that. Oh, yeah, I need to get the medical to you. Oh,
So
yeah.
you just do that today.
Probably good. He's have a history.
Thanks.
They're probably.
Ms. Wood.
Yes.
What are we doing with Mr. Burke?
We will do the final plea hearing today. I think this one will probably not be a trial, but we could just keep him on the August trial calendar, Judge, for now.
Okay, great. We'll do that and then we can get Ms. Ruff and her client together and we'll go there. Let me get the Cobb booth out of there. See if that ejects him.
Yes, your understanding that she placed was the initial to provision officers. I was thinking that.
There he is. Hey, Mr. Burke, are you able to unmute there? Great. Okay. We're going to have a quick conversation about your case. It sounds like it's not going to resolve today, but we can at least take care of the part we needed to and get you on your way. So let's get on the record. This is 24 SC 006 074, State versus Arthur Burke. Mr. Burke is appearing from the Cobb County Jail. What's up with the green outfit? I've never seen someone with one of those on. Is that standard for Cobb inmates?
Yes, Your Honor.
Okay, I guess we usually have Fulton inmates who are loaned out there and they're in orange. Okay. Ms. Wood is here in court. Ms. Wood, do you have what you believe to be all the discovery in Mr. Burke's case?
Yes, Judge.
Ms. Davis, if Mr. Burke wanted to resolve his case today, what would the state be recommending?
Judge, if because the defendant doesn't have a felony history, we would be recommending a probated sentence.
Is count six says it's possession of a firearm by a convicted felon or first offender. Is that a mistaken count or?
I think I'm looking at the right case, Judge. This is Mr. Rose.
This is Mr. Burke, number 5.
Oh, I'm sorry, Judge.
It's okay.
Have the official.
We've been producing him for a while. Has he been in Cobb for a while?
Yes, Judge,
Okay.
since last summer.
All right. What are you doing in Cobb County, Mr. Burke? Do you have an open case or are you serving a revocation or why are you in Cobb County Jail?
I have an open case.
What are the charges?
Possession of marijuana, a couple of possessions.
And you've been there that long?
Yes, Your Honor. Trying to get a bond.
Okay. All right. Ms. Davis, back to you and Mr. Burke.
Yes, our offer would be for counts 1 through 3, 5 years to serve 1 in custody. Of course, he would be getting credit for the time that he's already been in custody, which I think is around a year.
Mm-hmm.
For counts 4 through 5, we would be no crossing those. And for count 6, it would be 5 years probation consecutive to counts 1 through 3.
Okay, so total sentence of 10 to serve 1, balance probated, but credit for all the time he's been in custody. Mr. Burke, how long have you been in custody?
Going on a year.
Okay. All right. We understand what the state is offering. If you entered a plea today, the state would recommend 10 to serve 1, credit for the time you've been in, balance probated, so you'd be on probation for some years. But the custodial part of your sentence is almost over and they dismiss a couple counts. Do you understand what the state's recommendation would be?
Yes, Your Honor.
Okay. But it sounds like from Ms. Wood, that's not something you're interested in pursuing at this time. Is that correct?
Yes, Your Honor, it's just a couple charges that feel that I don't need to be convicted for.
Okay, I hear you. And certainly it's the state's burden to prove your guilt, not your responsibility to plead. So your case is going to move to our August trial calendar. And we'll get you here. If you're still up in Cobb, we'll get you produced to be down here for that. The only thing that changes after today, you can still work the case out, and it may be the state ends up changing the offer, or they're not going to pursue the count you don't want to plead to, et cetera. You can always enter a plea later on. You just don't get to withdraw that plea if the sentence I give you is more than what Ms. Wood asks for. Does that make sense?
Yes, Your Honor.
Okay. Well, at the latest, I'll see you on August 7th. That's when we're calling the trial calendar. But before then, if you and Ms. Wood work something out, do you have any questions?
Not at the moment, Your Honor.
Okay. Well, I'm sorry. No? Okay. Well, Ms. Wood will be out to see you before that trial date, or at least get you on a Zoom call or something like that. Ms. Wood, anything else on behalf of the defense?
No, Your Honor, thank you.
Ms. Davis, on behalf of the state?
No, Your Honor.
Okay. Thank you, Mr. Burke. You're good to go.
All right, thank you. You have a good day, Your Honor. Y'all have a good day.
Okay. Thank you, Deputy, for making him available. Appreciate it. All right. Can we do Mr. Sampson now? It sounds like that's not something we're resolving today. Okay. Mr. Sampson, if you'd come up to the podium so your lawyer can see you, I will add her to the spotlight and the podium to the spotlight. There we go. All right. Ms. Ruff, what I saw in your text was that you just got some additional discovery, and so you're asking that we bump this down the road a little bit. Tell me what it is that you received. Was it a police report or a statement from someone? What's the nature of what you got?
We just, my understanding is we just received the police report. My legal assistant is messaging me in real time as we receive this, but that's what we had requested, is any written reports, any written statements. And
Okay.
ADA Davis, immediately she just resent the original discovery, which was videos, and then included that as well.
Okay. I think I heard that. It's basically you resent all the discovery, Ms. Davis?
Sent it all, just sent them a new link.
Okay.
The evidence that was shared. It appeared that there were documents, videos, and I want to say audio that was shared originally in March.
Okay.
Just reshared it. Sometimes those links go missing and they expire.
Mysteries. Okay. So Ms. Ruff, my preference would be, rather than resetting this, would be to preserve Mr. Sampson's final plea rights, meaning at a later date, if he does want to enter a plea, I'm not saying you do, but if he does, he'd be able to withdraw that plea if the sentence I imposed was greater than what you asked for. But this is a 2023 indictment, and so I would very much like to keep the case on that August trial calendar. So my proposal is we preserve Mr. Sampson's final plea rights, and then we see all of you at the latest on August 7th. That's a ways away. If in looking through the discovery, you determine, now, wait a minute, it's more complicated than I thought, I have a motion to suppress or something like that, we can always tap the brakes. But I would like to have this continue to move forward. It's not going to get newer. And it's an indictment from 23, so the alleged conduct could be even older than that. Does that work for you, Ms. Ruff?
Yes, John, and that's perfect.
Okay.
Because I have a leave in September, so I'd like to resolve this in August.
I'm having a little trouble hearing you. Can you repeat that?
Oh, I'm sorry. I said, that's perfect for me, Your Honor. Can you hear me now?
Yes, now it's louder.
Okay, great. Thank you.
Okay, let me look up one thing here. Yeah, wow, this is from 21. I'm guessing you want to be done with this as well.
Yeah, yes, Your Honor.
Okay.
As quickly as possible.
Your bond order from July of 21, 4 years ago, says that you're to have no contact with a Taekwon Gerald Bly. Is that something that you've been able to do?
Yes, Your Honor.
Okay, great. That was the only condition. So keep doing that. Did you get something in the mail telling you to be here today, or did Ms. Ruff tell you to be here today?
Ms. Ruff.
Okay. Let me see if we have good contact info for you. You'll be back here on August 7th at the latest. If you and Ms. Ruff sort something out with the state before then, and I'll see you before then, but August 7th here in this courtroom is when we'd be next together. I have two different addresses for you. One is in Canton, Georgia, and the other's on Fitzgerald Place here in Atlanta.
Yes, that's my current address. I no longer live in Canton.
Okay, so the Fitzgerald Place?
Yes, Your Honor.
Okay, all right. We may need to switch that around. Ms. Davis, are you aware of any discovery issues other than Ms. Ruff saying, hey, I don't think I got it, but you've just resent everything?
Yes, Judge. Other than that, no, I'm not aware of anything.
Okay.
You should have everything, all the documents, videos.
Okay, then I'll move the case to the trial calendar, preserve the final plea rights, and we'll see where we go from there. Ms. Ruff, anything else on behalf of Mr. Sampson?
Not at this time, Your Honor. Thank you very much for your time.
Mr. Sampson, any questions?
No, Your Honor.
Okay, that's it. You guys are free to go.
Thank you, Your Honor.
Thank you.
All right, we've got Ms. Hamilton to talk about. We have Ms. Russaw, who is still on, and Rogers and Mender, we're not dealing with. We've got Mr. Rhodes, who's still here. Ms. Stone, you talked to, Ms. Rios talked to, so she's gone. And then we need to figure out what to do with Mr. Oliver's bench warrant.
Yes, Judge, I'm ready on Mr. Rhodes and Mr. Oliver.
Okay, let's start with Mr. Oliver and then we'll do Mr. Rhodes. All right, Mr. Oliver, come on up here, please. All right, so Mr. Oliver, let me get your case up here.
Oh, wait, this is yours. There you go.
All right, so you had a plea and arraignment date on May 6th, and that fell in that window when your mailbox didn't exist. Is that correct?
Yes.
Okay, and you still live at that Deer Creek Circle address in Lithonia?
Yes, sir.
Okay, how'd you get here today?
My sister drove me.
Your sister drove you this time. Okay, your mom drove you last time. All right, so Mr. Oliver is not driving. That's one of the conditions of his bond in this case. And are you going to be waiving arraignment on his behalf, Ms. Wood? All right. Ms. Davis, I think you were here when I was discussing what I learned from Mr. Oliver when he walked in last week about how the mailbox at the apartment complex was, actually his mom verified it as well. Mailbox is back. He's here. He's now been here twice in 3 days to say, I exist. I didn't mean to miss court. I'm inclined to set aside the bench warrant, but I certainly want to get your input on that.
No objection from the state.
Okay, so Mr. Oliver, I'll set aside the bench warrant. No more warrant for you. You'll continue to get stuff in the mail, so hopefully the mailbox exists. But more importantly, now that you and Ms. Wood are connected, she'll be reaching out to you. Did you give her all the ways to reach you? Phone, email, Instagram, your sister's number or your mom's number?
Give her my email.
Okay, give her that too. And then unless Ms. Wood needs you to stick around, you're free to go.
All right.
Thank you, Judge.
You're welcome. All right, and what are we doing with Mr. Rhodes? All right, Mr. Rhodes, if you come on up to the podium, please. All right, let's get on the record. 25 SC 000871, State versus Jason Rhodes. Mr. Rhodes is here in court with Ms. Wood, and Ms. Davis is here for the state. Mr. Rhodes, you are charged with aggravated assault and simple battery. Ms. Wood, do you feel like you've got all the discovery in the case?
Judge, we are missing the crime scene photos that are mentioned in the parts of discovery that we do have, and then also if the victim's medical records exist. And I've spoke to Ms. Davis about those two things, Judge.
Okay. The crime scene photos you're certainly entitled to. Is your read of the police narrative such that those would be important to see because it would show broken glass or this or that?
Yes, Judge, it's an interesting case, but there's mention of another person that's involved that's not charged. And truthfully, I don't know if APD actually ever found that person, but
Okay.
Yes, I'm interested to see those photos if they exist.
Sure. Okay. And then do you have reason to believe that the alleged victim received medical care?
He went to Grady. There's body camera from Grady. But again, I don't think the wound that took him to Grady is actually related to Mr. Rhodes, but if they exist, I would like to see them just to rule that out.
Okay. So there's a Drexel Tucker. I'm assuming that's the one who had a wound, but then there's also an Aiden Tucker.
That's the son.
That's the son. The
Yes.
simple battery alleges the insulting, provoking contact with Aiden. And then, so Drexel is Aiden's father?
Yes.
Okay, got it. But then there's a fourth person potentially.
Yes, Judge.
Okay, all right, chaotic scene. Ms. Davis, what's your understanding about crime scene photos?
Yes, Ms. Wood did reach out to me yesterday, so we're going to reach out to APD to see if those photos do exist. I did speak with one of the witnesses, the wife of the victim, about medical. And so to the extent that I can provide it, I will attempt to provide that information to Ms. Wood. She is correct. There was an injury and then later it was discovered a more serious and grave injury, and he was in the hospital for some time.
Mr. Tucker was?
Yes.
Okay, and the state's contention is that the more serious injury is connected to this, not that he went there because he had a bump on his head and they found a tumor on his liver. That's not connected. Okay. So that, we'll get that stuff, well, the state will need to get that to Ms. Wood. I guess the medical records, you also co-work through me to get that through Grady, from Grady as well. So if you're hitting a dead end, let me know. Ms. Davis, what is the recommendation in this case if Mr. Rhodes wanted to resolve it today?
Because Mr. Rhodes only has a misdemeanor history.
This is who you were talking about earlier. Yes.
I wanted to give them context for the offer. It was a completely probated sentence, 10 years probation, anger management, 60 hours community service, and be gainfully employed or obtain his GED if he doesn't already have it.
Okay.
That was it.
Got it.
Stay out of trouble and do anger management.
Okay. Mr. Rhodes, do you understand what the state's recommendation is in the case? If you were to enter a plea, the state would recommend 10 years probation and some conditions to probation. You understand that?
Mm-hmm.
Yes?
Yes.
Okay. Ms. Wood would be free to recommend less, although the state's not recommending jail time, so the less would mean less probation if you were going to enter a plea. If I were to sentence you today to more than 10 years probation, so either more probation or any jail time, actually, let me say that differently. If Ms. Wood, I'm going to make it up, let's say she asked for 5 years probation. If I were to sentence you to anything more than what Ms. Wood asked for, you'd be able to withdraw your plea today. After today, if you enter a plea and I sentence you to more than what Ms. Wood recommends, you don't get to withdraw your plea. It's like if you go to trial, if you're found guilty at trial, you don't get to say, I don't like the sentence. I want another trial. So I just need to make sure you understand that today you could withdraw the plea if I exceed what your lawyer asked for. Tomorrow, next week, next month, you can always enter a plea. You just don't have that safety valve if I exceed the sentence that your lawyer recommends. Do you understand that?
Yes.
Understanding those things, do you want to resolve your case today with a plea to what's charged in the indictment, or would you prefer that your case go to a trial calendar?
I prefer to go to the trial calendar.
Okay, that's what Ms. Wood forecast for me. I will see you at the latest on August 7th.
Okay.
This courtroom, that's when we call the trial calendar. That's not when the trial starts. Between now and then, hopefully your lawyer gets the crime scene photos, and we'll figure out what's going on with medical records. Those are kind of equally accessible, meaning Ms. Wood can petition me to issue an order to get Grady to provide them because they're related to this case. But it's usually more efficient for the state to get them, especially if Mr. Tucker were to sign a waiver, because it's private information. Either way, the goal is to get that to your lawyer so she can get a better sense of the severity of injuries and your connection to those injuries, if any. So if between now and August 7th, everyone works something out, you come into court, we'll deal with it then. Otherwise, August 7th is when I'll see you next. Any questions about that?
No, sir.
Okay, you'll need to continue to have no contact with Mr. Tucker. That bond condition remains in place.
Okay.
Ms. Wood, anything else on behalf of Mr. Rhodes?
No, Judge, thank you.
Ms. Davis, on behalf of the state?
No, Your Honor.
All right, thank you. Do you need Mr. Rhodes to stick around?
He's good to go, Judge.
All right, thank you for being
Have a
here.
great one.
Right, I'll be in touch. Thank you.
Tim, Russa, Deputy Gordon oh no, they're not coming. That's it. So we don't have anyone back there. Oh, we have Lemons for this afternoon. Okay, great. The gentleman in Cobb, we did, and let him go and thanked Cobb.
Okay. Judge, so we will have a plea for all four of Ms. Hamilton's cases.
Or,
Yes, there's two that are not on the calendar. And then I'm gonna step out if that's okay with the court, just to give Ms. Russell a call. That should be a plea as well, Judge.
great. All right, I'm good. And you have all four case numbers. You go talk to Ms. Russa. I'll get those other numbers if I can't find them from Ms. Davis.
Thank you.
I just feel like. That's something that. That's something that makes me feel like that. Yeah. They don't have a job. So just say, so like. You know, if I got a person.
Don't, that's our little summer intern guys with him this week, so we could find out. So that spilled, oh, you're right, because you said they were deliberating yesterday, even though they might have been picking a jury. They didn't go out on something else. That was a strange case. Yeah, okay, you're more familiar with it. The intern was telling me about gender identity and killing and all that kind of stuff. It's one we really should have saved for Emerson. He likes getting those.
Yeah, that's what I just feel like. It is that's me, that's not there. No, I'm hard to from that.
Ms. Davis, do you have the other case numbers for Ms. Hamilton?
I do, Judge. I was gonna send you an email.
Okay.
We're getting in the weeds.
All right, email's great. That'll work.
So stuff.
Email will work. Thank you.
He's just got the name of the.
Yeah,
Yeah, and I'll look at their case.
Okay, so on, we would just do on this one, 12 months probation to count two.
Oh,
Okay,
12-month probation and, yeah,
Got it.
literally take medication, no harassing contact.
okay. And I did confirm she doesn't have her, she's working with defects in
Yeah.
that case plan, so she's got visitation, but she does not have custody of her kids.
Yeah, that's.
Yeah.
And then what's each other? Oh, yeah, just follow on scroll. So this is the position two. To current, the criminal damage involved door, 12 months consecutive this.
Okay.
So that she's actually in probation for it.
Got it.
Okay.
Got it.
Okay, and then these are all the, all the people. And it's all up to the.
Okay. Thank you.
Ms. Wood, let me know when you are ready with any of these and we'll make it happen.
Mr. Judge, I will be ready on, Ms. Russell first.
Okay. Do I have a quick second or you're ready now for her?
Oh, I need a second too.
Okay, great. I will get,
Oh, no, I have two. Yeah, so Simpson, I talked to our attorney. From home? Yeah. Yeah, that's really not, you can't just say it. That you don't know. That's why I said, if you say it.
Yes.
Are we ready now? Excellent. Let's get everyone in place. So this is Ms. Russa we're doing? So we'll add her to the spotlight and that. And okay. All right. Ms. Russa, can you unmute, please? Great. Can you hear me now?
Yes.
Okay. Ms. Wood tells me that you are prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. Well, we're going to get on the record in your case. It's 25 SC 000153. You're represented by Ms. Wood, who you can see on the screen there, wearing the dramatic animal print blazer. Ms. Davis is the prosecutor. She is sitting at the screen with the floral pattern and the black blazer. You see her?
I don't see anyone.
She just held her hand up. You
I don't
should,
have the screen.
on your screen, do you see 4 boxes?
No.
What do you see?
I just see where they were sitting at.
Okay, well, let me get this off the screen. Now what do you see?
The same thing. I just see where they were sitting at before.
Okay, well, as long as you can hear them, they're on the screen. I'm not quite sure what you're seeing, but the prosecutor is here as well. She's going to put you under oath in just a moment and then ask you a bunch of questions. You need to answer those truthfully and completely. I need you to let me know at any point if you've got questions of your own. Will you do that? If someone says something you don't understand or it's not going the way you expect, will you stop us so that I can answer your question?
Yes.
Okay. Ms. Rosa, do you waive your right to be here in person in court and agree to proceed appearing virtually?
Yes.
Okay. Do you waive your right to have Ms. Wood sitting right next to you in court? But if you do need to speak to her privately, we can arrange that.
Okay.
Okay. Then we're going to go forward. Ms. Davis, when you're ready.
Ms. Russo, will you raise your right hand?
What you say?
Miss,
Hello?
is it Rissa or Russa?
Can you hear her now?
Rissa.
Yes.
I'm sorry. Miss Rissa, will you please raise your right hand? Do you swear or affirm the testimony that you shall give in the matter before the court today shall be the whole truth and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true and correct legal name for the record.
Sharday Russell.
Please spell your first and last name for the record.
SHARDA, last name RUSSAW.
Are you at this time under the influence of any alcohol, drugs, or medication?
No.
Is there a medication that you normally take that you have not taken today?
No, I take therapy. I go through therapy counseling.
Okay, but the therapy, that's the extent of the treatment? There's no medication associated with the therapy?
No.
Okay.
How old are you and how far have you gone in school?
I'm 36 and I went to the 10th grade, stopped at the 10th grade.
What high school did you attend?
Grady, high school.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with a misdemeanor count of simple battery? And indictment 25 SC 00153.
Yes, the simple battery.
Yes.
That's the least misdemeanor that I was able to be given.
Yes, and the state is moving to null pros count 1, willful obstruction of a law enforcement officer by use of violence. And that was the felony, which we are null prosing or dismissing.
So the felony, I mean the misdemeanor come from the officer?
Correct.
So, Ms. Rasa, you are pleading to just count 2 of the indictment. Your indictment has 2 counts. The first indictment charges you with, this is just the allegation. I don't want us to have a back and forth right now. Something about kicking the officer Stover while Officer Stover was doing his job. And then count 2 is going to sound very similar. It's the misdemeanor simple battery that said that you harmed Officer Stover when you struck him. And the state is agreeing to dismiss count 1, the felony, and just go forward with count 2, which is only a misdemeanor. Does that make sense?
It makes sense, but they said something else just popped up on here and I don't know what it's regarding. So I don't know if I take this plea that it's going to be the same. It's like I'm trying to do the same thing when I was in a mental situation at the time.
Okay, well, let's hear. I know there's a warrant rattling around out there. Ms. Wood, tell me what you think Ms. Rasa is concerned about.
That's what she's referring to, Judge.
Okay.
I shared with her some information about that to the extent that I had the information. And she's very upset about learning about that because she doesn't know anything about it. I explained to her that that is something, I don't think it's anything that we can actually take care of today.
Mm-hmm.
But I told her that after we get done with this plea, that I'm happy to help her figure out where that case actually is and who we can talk to about that case.
Sure. What do we know about any warrant? Is it from another jurisdiction? A magistrate warrant in Fulton County? Okay. Do we have a warrant number or case?
I didn't see a case number. Is there a case number?
I didn't see a case number. All I saw was the warrant numbers. That's in policy.
Okay. Ms. Rasa, what we're doing today is not going to affect that situation. I don't want you to worry about it. I don't know what that situation is. I don't have that magistrate warrant in front of me. But what I do know is that Ms. Wood is going to help you figure out what that situation is all about. If it relates to this case, that's a simple one because then it will go away because you're resolving this case. If it relates, pardon me?
Yeah, I said, okay, I'm just trying to see because I haven't been incarcerated or anything else since this situation.
Well, and it may not even relate to having been incarcerated. I'm not sure. Magistrate is the lowest class of court. I don't mean that in a negative way, but that's where like the simplest stuff happens. And so you and Ms. Wood are going to want to clear up whatever it is. But what we're doing today isn't going to impact whatever that situation is. So you don't need to worry that, if I plead guilty here, am I going to make my magistrate situation worse? That's not how it will go. Okay.
Okay.
All right. Let's keep going.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
I got the offer today, so I mean, I had to just take on the plea. just knowing it right now.
So Ms. Russell, I want to cover a couple things. I know you just got the offer today. That's probably because Ms. Wood just got the offer today. But the question was a little different, which is, one, have you had an opportunity to talk to Ms. Wood about your case? And then two, so two different questions. Do you understand that if you do enter a plea, then if there was a defense to the case, like you weren't there, you have an alibi, or at the time you were going through a crisis, which might explain some of your conduct, those defenses you're waiving because you're saying, look, I'm going to admit guilt. I got into this tussle with the officer and I'm ready to move on. Do you understand all that?
Yes.
Okay. And do you need more time to talk with Ms. Wood at this point, or do you feel like you understand what we're doing and where we're going?
I was in a mental thing, so is that recorded? Because I had sent everything in for evidence as far as me being going through a mental situation after the accident.
You're
So
saying
it wasn't just my own actions. I was going through a mental situation. That's why I'm having to go through the classes and stuff.
got it. Okay. I think that's something Ms. Wood will tell me about when she's given me your side of the case. Okay.
Yeah.
All right. Let's keep going.
Are you satisfied with her services, Ms. Wood's services?
Yes.
Ms. Wood, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
Go ahead.
Ms. Roussel, do you remember being arrested on these charges?
Yes, I remember being arrested.
Okay. Judge, the state is unaware of any additional warrants related to this matter. Ms. Wood, are you aware of any other warrants related to this particular matter?
So just for the record, the active warrant that we're all referencing, when you click on it, it does have this same case number. If it's connected, Ms. Roussel, I promise we will do everything we can to clear it up if it's connected to this case. So I don't know what that's about, so possibly, but yes, I will definitely look into this after court today.
Sure, but in some ways, it's never good to have a warrant, but in some ways, this is the best possible warrant to have because we are resolving that issue right now. And so that'll be the easiest warrant to make go away if the warrant is somehow connected to what happened in October of 23, when you were having your crisis and you and that officer had that interaction. We're resolving it today, and that'll make the warrant go away, assuming the warrant is about this case. So we'll keep working on that.
Ms. Roussel, has your attorney advised you of the minimum and maximum sentence for this misdemeanor, which is the maximum sentence you could possibly receive will be 12 months to serve? That is not our offer, though.
Say what?
Did Ms. Wood?
Yeah, I know.
Yes. Are you aware of the minimum, which would be probation, and the maximum for this charge, which would be 12 months to serve? However, that's not our offer, but are you aware that could be the case?
I'm aware of it now. I was just aware of the 12 months probation.
Okay, thank you. Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court? And as you stated, it will be a probation sentence is what we're recommending.
Yes.
Do you understand the court is not required to accept the state's recommended sentence?
You said, do I understand that the court is not required to?
Right. I don't have to do what your lawyer and Ms. Davis have recommended. I am often persuaded by that, but I'm not the one who entered the negotiations. And so I might do something different from what Ms. Wood and Ms. Davis have been talking about. But if I do something different, you'll have the ability to say, well, no, thank you. My lawyer said it would be X and I was willing to do X, but you just said Y, Judge, and I'm not interested in that. Okay?
Okay.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes. Hold
Do
on,
you-
you said that it won't have anything to do with the other case if it's got something to do, correct.
Correct.
If it's together, right? With
Correct.
the other charge.
It sounds like it's connected to that warrant. What Ms. Davis was telling you about is a little bit different. Let's fast forward 2 years. So now you are 38 years old and you get in trouble for something else. And I hope you don't ever get in trouble for anything else. But if you get in trouble for something else, a judge could look at this case and say, well, come on, Ms. Russell, here we are again. You got in another fight with an officer. Enough is enough. And so all Ms. Davis is letting you know, and it's common sense, if you were to get in trouble in the future, this situation could be used by a prosecutor or a judge to say your new situation is now more serious. Does that make sense?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? That is true regardless of any advice by your attorney or anyone else. Do you understand that? Do you understand that by pleading guilty do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be if there was a trial?
Yes.
Okay, and I'm going to give you some examples. Like your guilty plea may affect your right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, which actually doesn't apply because this is not a felony, but it may impact your ability to obtain employment. Do you understand that? Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea?
So Judge, before you move on to 2.10.30, I want everyone to be aware that the state and the defense submitted that charge. However, they submitted 2 different versions. So I placed them both there so that the parties can decide which one they want the judge to read to the jury.
That's fascinating. That's coming through our podium.
What's going on?
Someone else has patched into 8D. That happens every once in a while. Another judge grabs it. They need to get off it. But let's go back to this and hopefully that mystery speaker about 210, whatever, will be quiet.
Do you understand, Ms. Russell, that you waive any and all defenses, including mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
The second version came from the state. That was the one that the state proposed. And this version is actually
What is this other
prior
person
to
saying?
the
'Cause I don't know what's
change
going
in the
on.
jury
Okay,
charges that are
I don't know
suggested
how to
by the
kick
jury. So it's just
someone
an older
out.
version,
Um,
Mr. Mackey.
Ms. DeMecki, so we need to figure out which courtroom that is. Oh, well, let's keep going.
Okay. The right to testify on your own behalf and to present other evidence.
So I have the right to present other evidence.
If you went to trial, you'd have the right to present evidence, but because you're pleading guilty, you're giving up that ability to present evidence at trial, because there's not going to be a trial because you're entering a guilty plea.
And Judge, when it's my turn, I have the mitigating evidence that she has sent me that I will definitely share with the court.
Right, great point. So we're still going to talk about those things you want Ms. Wood to talk about. We will hear about what was going on in your life at the time you and this officer had this encounter. So I'll hear that today. That's just not anything that a jury would hear at trial, because you are saying, no thank you to a trial. I want to take a misdemeanor plea.
Okay.
Okay.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 12 months from today, for this misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the indictment 25 SC 00153 to the misdemeanor count of simple battery?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes.
Judge, we believe the facts would show at trial that on October 25th, 2023, officers with the Atlanta Police Department responded to Belford Pines Apartments located at 509 Boulevard, Northeast Atlanta in Fulton County in reference to a woman who was on the balcony. The officers were approached by some juveniles who indicated that the defendant was holding some of her children off of a balcony. Officers approached the apartment and tried to enter the door, but it was locked. One of the children on the balcony was able to throw a set of keys to the door to the officers. But while that was going on, another officer attempted to basically shoot out the lock. That did not work. They used the key to enter it. When they entered the residence, the apartment, they were able to make contact with the defendant, who appeared to be having an episode, and basically diffuse the situation. But while they were attempting to take the defendant into custody, she attempted to bite the officers and kick one of the officers and make contact with them.
Okay.
And so in light of the circumstances and the situation, I know Ms. Wood will speak to it more, but we believe it would be probably in the best interest and more appropriate. This defendant does not have a felony history to have a probated sentence for 12 months with really the conditions being that she continued to pursue her mental health treatment, whatever that looks like, whether that's therapy or medication or both, and to have nonviolent harassing contact with the minors, her children.
Okay, got it. Thank you. Good morning, Ms. Jackson.
Good morning, Your Honor.
Do you have any criminal history information for Ms. Russa?
There are 5 cycles. The last arrest was November the 30th, 2009, with the City of Atlanta Police Department for aggravated assault. She did receive first offender treatment in 2011 for aggravated assault. That case was sealed November the 7th, 2017. Nothing in addition, Your Honor.
Thank you. Ms. Wood?
Thank you, Judge. So leading up to this incident in October of 2023, Ms. Rosal had been injured pretty significantly in a car accident. She did share with me some hospital records. She had some head injuries. And then after that, she had an issue where she was awarded some money from that car accident. Her family member stole it from her. She had basically just a series of unfortunate events that all culminated with this incident where law enforcement got involved. Judge, since this time, she's been working diligently to get her life back on track. She was working at Spelman College, although she starts a new job tomorrow at Atlantic Station. So she's very excited about that. Her 2 children, Bella and Beautiful, are currently in the custody and care of DFACS. However, she's been working really hard with her caseworker on her parenting plan. She's sent over documentation. She completed a parenting course in April. She sent me a letter for her therapist at True Unity Mentoring. They said she's just doing wonderful. And then she's also done some therapy through Mending Mind. Judge, I'm sad that she was charged since the officers knew that she was having a mental episode, but, they believed that she was being aggressive with them. And so she, in the interest of moving forward, she's here accepting responsibility for that. So yeah, we just ask that you accept the state's recommendation. I would ask, since she's starting a new job and is just trying to get stable, if the court would consider waiving probation fees in this case.
Okay. All right. Ms. Russa, how old is Bella?
Bella is 10.
How old is Beautiful?
She's 9.
All right. What job are you going to start at Atlantic Station?
Custodian.
Where?
I don't have the information. I guess it's just from Atlantic Station, the Rieger, theater. But I have more information to submit with her, but this, my first day is just a custodian position for Atlantic
At the movie theater.
The whole Atlantic Station part.
Okay. But I mean, you know where to go tomorrow to meet up to start the job.
Right.
How did you get the job?
I applied through Indeed. They accepted my application and reviewed it and called me.
Okay. Well, congrats on that. Do you have any questions about anything we've been discussing?
No, just the other thing that popped up that you said we'll be able to speak about.
And what's that?
As far as the warrant that's being lifted off the other charge.
Oh, right. We can talk about it more. We are not able to, in the computer system, pull it up specifically, but when Ms. Wood clicks on it, it seems to be connected to this. And so I'm happy if we're able to ever track it down, make clear that you've resolved this case, so there shouldn't be any warrants in connection with this case. I don't have more information than that, but Ms. Wood is going to work to get that additional information. And if there's anything I can do to fix it, she will reach out to me and I'll make sure I take care of that.
But I have one other question. Would it be any more consequences behind it since I'm doing everything together?
If the warrant relates to this case, then there will be no more consequences. If the warrant relates to something else, you'll need to deal with whatever that something else is. But what we did today will not have a bad consequence on whatever that other situation is. I think the warrant, but I'm guessing, I think the warrant's somehow linked to this. And then we just need to make it go away. But I can't just wave my arms and say, warrant, go away. I'd actually need the warrant number and a chance to look at it. And if it is related to this case, that's a very easy fix. If the warrant is related to,
I'm listening. She said it was going to be lifted anyway if I took the plea, that the warrant be lifted because I was in court today. I don't know.
Okay, well, if the warrant relates to this, then it would be. But again, we need to get that warrant number. And I know this seems like an unfair situation because we keep talking about a warrant. I don't know how anyone can know you have a warrant if they don't have that warrant number. But someone says there's a warrant in a system. There's nothing you need to do. You should go to work tomorrow, start your job, and Ms. Wood's going to try to sort this out. Okay?
Okay.
Do you have any other questions?
No.
All right. Tell me how often you go to therapy and where you go.
I go to therapy. What's the name? My therapist is here now, just waiting. What's the name of your therapist?
It's under True Unity Mentoring, but then we also have Nichols Counsel.
She said we doing Nichols Counseling and True. The one that I submitted through the parenting. It's the same company.
Okay. And how often do you go?
I go once a week for both.
Okay.
So I do both of them once a week.
Got it. And you'll still be able to do that even though you've got this new job?
Yeah, we're going to work around the off days.
Okay. Well, Ms. Russell, I find there's a factual basis for your plea and that your plea is knowing and voluntary. Knowing means you've understood what we talked about. And if you didn't, you ask questions. And I saw that happen. And voluntary means no one's forcing you to enter this plea. Do you agree with that?
Yes.
Okay. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Davis?
Yes.
Ms. Russell, is it okay if we sign your name on the indictment indicating your plea to count 2 only, the misdemeanor?
Yes.
All right, we'll do that. Count 1 is being dismissed. I will follow the negotiated resolution here, and on count 2, I will sentence you to 12 months probation. That's misdemeanor probation. You'll get information about how to report and where to report. I will waive any probation supervision fees for the first 6 months. And the 2 special conditions of your probation are: 1, you continue any and all therapy that you've been receiving. And 2, if you do get to spend time with Bella and Beautiful, that you have no violent contact with them. They're bigger now, and you need to be the loving mom I know you want to be. And that'll just be one of the conditions of your probation. Ms. Davis, anything else from the state?
No, Your Honor.
Ms. Wood, on behalf of Ms. Russa.
No, Judge, thank you.
Ms. Russa, anything else before we wrap up?
So what would be the fees for the other 6 months?
I don't know what the monthly fees are, but they are income based. And so if you are not making a whole lot of money and have other expenses, they work with you on that. But it's not thousands of dollars. It's double digits. I just don't know if it's $50 or $20 or what.
Okay.
Okay. And if we get to that 7th month of your probation and maybe you don't have your job anymore or times are tough, you can always let Ms. Wood know and she can let me know, and we can talk about addressing those fees. They are not a reason that's going to get you into trouble, okay?
Okay.
Any other questions?
No.
Okay, thank you so much. You're free to go.
Okay.
All right. Ms. Hamilton, can you turn your microphone on, please? Hey, Ms. Hamilton, there you go.
I can hear you.
All right. Can you hear us?
Yes, sir.
Good, we can hear you. So Ms. Hamilton, you've got a lot of moving parts today. You have 4 cases, and we're going to get on the record in a minute. Sounds like the state's going to dismiss 1, and you are pleading to the other 3. Is that your understanding?
Yes, sir.
Okay. Well, let's get on the record. We have Marie Hamilton, who is appearing virtually. Her lawyer, Ms. Wood, is here in court, and the prosecutor, Ms. Davis, is here in court. We're going forward with pleas on 24 SC 002060, 24 SC 001824, and 25 SC 003180. Assuming those pleas happen, the state is dismissing 24 SC 001980. Ms. Hamilton, in a moment, Ms. Davis is going to put you under oath and then ask you a bunch of questions. You just got to hear what all those questions are with Ms. Russa. You need to answer the questions truthfully and completely. If you have questions at any point, will you let me know?
Yes, sir.
Okay. And when Ms. Davis is done, then I'll hear from Ms. Wood, and I'll hear from you if there's anything you want to add. But Ms. Davis will put you under oath. Before we do that, Ms. Hamilton, you are appearing virtually. Are you waiving your right to be here in court for your plea hearing?
I'm sorry?
You have a right to be here in court in a public space where everyone can see you, but you are appearing virtually instead from this kitchen. I just want to make sure that you are waiving your right to be here in court and you're agreeing to appear on screen.
Yes, sir.
Okay, Ms. Davis, when you're ready.
Ms. Hamilton, please raise your right hand. Ms. Hamilton, can you hear me? Rashida Davis, can you please raise your right hand?
It's just, I think it paused. It had paused a little bit.
Oh, okay, my apologies. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down.
Okay, it froze, so,
Yeah, I can see.
oh my God. Okay. Is it working? Cause it's freezing on my end.
It's working now. We'll try a little bit more, but if it keeps freezing, then we're gonna need you to come down to court this afternoon. How far away are you from the courthouse?
I'm not that far.
Okay. All right, well, let's give it a try and see if we can do it. Otherwise, we'll get you down here this afternoon.
Yes, sir.
Please state your true, correct, and legal name.
Marie Lachey Hamilton.
Okay, please spell your first and last name for the record.
MarieHamilton.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
Yes, this medication that I take, I need a chance to get down to the jail and my 30-day supply.
Does that have an impact on your ability to understand the proceeding this morning?
Can you hear me?
Yes, I heard you. Does that impact your? No? Okay. How old are you and how far have you gone in school?
I'm 33 years old. I have a high school diploma.
Where did you attend high school?
Atlanta Job Corps.
Do you understand that you are charged with the following offenses? So for 24 SC 002060, you're charged with the count of willful obstruction of a law enforcement officer. And 24 SC 001824, you're charged with one count of aggravated assault. And in 25 SC 003180, you're charged with one count of criminal damage to property. Do you understand that?
Yes, ma'am.
Okay. And all the other accounts that are associated with those different cases are going to be dismissed by the state for this plea.
Okay.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you would receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you about these indictments and any potential defenses?
Yes.
Do you need more time to discuss these cases with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, I am.
Attorney Wood, do you waive formal reading of all these indictments and any and all defects therein for the purposes of this plea?
So wait.
Ms. Hamilton, do you remember being arrested on these charges?
Yes, I do.
Your Honor, the state is unaware of any outstanding warrants related to this case and the subsequent cases. Attorney Wood, are you aware of any outstanding warrants related to these matters?
I am not.
Ms. Hamilton, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading to today?
Yes, ma'am.
Okay, and for willful obstruction of a law enforcement officer, the maximum sentence is 5 years. For aggravated assault, the maximum sentence would be 20 years. And for criminal damage to property, the maximum sentence would be 12 months.
Yes, ma'am.
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, I am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that there are multiple charges to which you are pleading guilty today, and the court has the right to run those consecutively or one after the other?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as others, including federal courts?
Yes, I am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or impact your ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, yes, I do.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I do.
How do you plead to 24 SC 002064 willful obstruction of a law enforcement officer?
Guilty.
How do you plead to 24 SC 001824 aggravated assault?
Guilty.
How do you plead to 25 SC 003180 criminal damage to property?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, it is.
Your Honor, the state believes at trial for indictment 24 SC 002060 that the state would prove on August 25th, 2022 at 851 North Avenue in Atlanta, Georgia, Fulton County, that the defendant, as the officers were responding to a call at that address, that the defendant became combative when she was being detained. Victims had flagged down officers to help assist with the defendant, who had been breaking a window out of a location. And when they attempted to detain the defendant and place her in the vehicle, she kicked both officers. They did sustain visible marks from her kicks, and that the defendant had received multiple trespass warnings from that location.
And what was that location to her?
I believe that was the address that her mother was staying at the time.
Okay. All right.
And 24 SC 001824, the state would believe that a trial we would show on May 24th, 2023 at 851 North Avenue in Atlanta in Fulton County, Georgia, that the defendant did assault the victim, Timothy Foe, I believe you pronounce his name. Officers responded to that location. They noticed that a white male was suffering from a deep laceration to his head. They attempted to make contact with him and talk to him. However, he was not fully coherent. They spoke with a witness and also a victim at the time, Carolyn Wright, who stated that her and the male, Mr. Timothy Foe, had been attacked by a known person, that is the defendant. When she came home, Marie had started hitting on them, and that's how Mr. Foe sustained injuries to his head. The tool that was used was a wooden broomstick, which caused him to bleed.
And their connection to Ms. Hamilton?
I think they just know her.
Okay.
They're just associates, but
Okay.
unrelated.
All right.
And then in 25 SC 003180, on January 25th, 2025, at 474 Sunset Avenue, the officers were called to that location. They did personally observe the defendant actively swinging a wooden stick at the front door. This is or was the home of the defendant's mother, Miss Patricia Hamilton. They gave her verbal commands to stop. She threw down the wooden stick and was detained successfully. The door, however, sustained many dents and marks, broken glass. The glass was completely shattered. And it's my understanding that the owner of that property is Kasim Benu, who I spoke with, and it is being reduced to a misdemeanor because the damage was $427.98.
Okay.
And unfortunately, I believe the mother was evicted from that location as a result of this altercation and the damage to the property.
Okay.
My computer's loading back up, but I do believe the recommendation for 24 SC 002060 would be 5 years to serve 2 years, giving the defendant credit for the time that she had been in custody, which I believe would be in excess of 2 years. And for case 24 SC 001824, the aggravated assault, for that to be a sentence of 10 years probation with 2 of those years to be served, that would be concurrent with 24 SC 002060. And then for the last case, 25 SC 003180, criminal damage to property, that is going to be a probated sentence because the victim is seeking restitution for the damage to the door. Code enforcement was called on him later, so that's why he's really seeking for the damages to the door. That is to run consecutive to 24 SC 002060. So in total, in sum, it shouldn't be 10 years probation with 2 of those years to be served in custody, which she has already done. So at 8-year probated sentence, Ms. Hamilton is to continue any mental health treatment and medication, to do anger management, to do an alcohol and drug evaluation and treatment, and have nonviolent harassing contact with all the victims, which would be Patricia Hamilton, her mother, Michelle Hamilton, her sister. That was the case that we dismissed. Timothy Foe, the associate, Carolyn Wright, and Benu Kasim, who was the owner of that residence, and a restitution of $427.98.
Okay. I follow all that. Ms. Jackson, can you share the criminal history information you have for Ms. Hamilton, please?
Yes, Your Honor. There are 11 cycles. The last arrest was October the 10th, 2024 in Fulton County, where a failure to appear, the underlying charge, was not listed. Does have misdemeanor convictions. It's one in 2018 for simple battery. It's an additional one in 2018 out of DeKalb County for simple battery. And there was one in 2014 for simple battery. Nothing in addition, Your Honor.
All right. Ms. Wood, I'm familiar with Ms. Hamilton because for a bunch of months we tried to make things work in drug court, and there were times when it went well for her, and there were times when she was very candid about her struggles and said, I'm gonna drink. I drink because that makes me more comfortable around people, and I want to be around people. And in the end, drug court didn't work out. She picked up some new charges, and her cases from drug court came here, plus this new case. And it sounds like today we're trying to wrap all those up.
So as you know, those cases that were with drug court were there on the diversion track.
Mhm.
So we will be asking for these sentences to be consolidated and requesting her submitted treatment. I've gone over the pros and cons of that with Ms. Hamilton. Judge, she is 33 years old, she's a high school graduate, she's a lifelong resident of the area. She recently got out of jail as in this weekend, and that was part of the Ebenezer Baptist Church Juneteenth bailout program. And amazingly, they are gonna be working with her. She agreed to work with them. They have people that are volunteering. Part of the intake process was she was able to speak with them about some of the things that she struggles with. So in addition to the anger management and the other treatment that the state has recommended, I just wanted the court to know that she will be working with them. I don't know the specifics on how in-depth or how long that goes.
But the entity is the Ebenezer Baptist Church.
Yes.
Okay.
And so they have volunteers she agreed to work with them for some social services. And so I believe her appointment with them is next week. I'll let her tell the court.
Okay.
If she wants to share more about that, Judge. But we will ask that the probation fees be waived so that she can pay that restitution off. She will be needing to look for work now that she is on the outside. And I am also requesting a behavioral improvement date. And finally, Judge, I can't remember if I said this already, but collectively on all 4 cases, she did 745 days.
Yep.
She has shared with us that that was a wake-up call, and we're hopeful that even though drug court was not a good fit for her, that wake-up call will keep her on the straight and narrow now, Judge.
Okay. Ms. Hamilton had been in since January 25th, so her arrest for bashing up the door and window at her mom's place, that's what she just got bailed out for, courtesy of the Ebenezer Baptist Church Juneteenth bailout.
Yes, Judge, and if I could just add, for that case, so she had a $1,000 bond. There was an issue, a former bench warrant from drug court days was still showing with jail records. It took us a while to get that straightened out, so that is part of the reason she sat so long on the $1,000 bond.
Okay. Got it. Ms. Hamilton, is there anything you want to add?
No, sir.
Okay, well, I appreciate you listening. Tell me where you are staying now. You just got out, so you're probably just back on your feet. Are you staying with friends or family or what?
I'm staying with my niece,
Your niece, how old is your niece?
20 years old.
Okay, and is she a student or is she working?
She works.
What does she do?
She works at FS. It'll be a job that I'd be going back to myself.
And what's that job? Warehousing work?
Yes.
Okay, and where is her apartment?
Her apartment is on 1483 Arthur Langford Jr. Place, Atlanta, Georgia 30315.
All right, and is that where you are right now?
Yes, I am.
Okay, and is your cousin gonna be able to let you stay there for a little while, or does she need you to get out?
She's letting me stay here until I get on my feet.
Good, well, I hope you are grateful to her. How's your mom doing?
She's fine.
Have you spoken to her since you got out?
Yeah, I spoke to her. She glad that I'm out. She just want me to be on the right track.
I'm sure she does. I think that's what most of us want, Ms. Hamilton. And you said something about medication in the jail. Were you released with medication or without?
I didn't get a chance to get it. They told me to come back Monday, but I couldn't get up there to the jail, so I got to go up there and get the 30-day supply.
You really do. That's going to be real important. When are you going there?
So I can go tomorrow.
Okay, let's make that happen. Well, Ms. Hamilton, I find there's a factual basis for each of your 3 pleas, and that your pleas are knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to do it. I'm sentencing you pursuant to the Probation Options Management Act, which means just that while you're on probation, which you will be for a little while, if you have a real basic violation of probation, you and probation will solve that. But if it's more serious, you get arrested again or something like that, that'll come back to me and it'll be a little more problematic for you. Ms. Wood, can someone in my office sign your name to the 3 indictments?
Yes.
Ms. Davis?
Yes, Your Honor.
And Ms. Hamilton, is it okay if we electronically sign your name to the 3 cases indicating your pleas?
Yes, Your Honor.
Okay, we'll do that. And then the 4th case is being dismissed. On the case of 24 SC 002060, that's the fighting with the officers case, where they came upon you when you were breaking a window at your mom's. Your sentence is, and is that let me get that indictment back up. So that has 3 counts. It's a plea to all the counts, but the overall sentence is 5 served 2, or was it a plea to just the obstruction count?
Just the obstruction. count.
Okay.
I believe the others are misdemeanors. I believe.
Okay, so you're null processing those?
Yes.
All right, so count 1, your sentence is 5 years to serve 2 years with the balance on probation, but you're gonna get credit for the more than 2 years that you served, so you're gonna stay on probation. Special condition of probation number 1 is that you take an anger management course and complete that. Special condition number 2 is that you participate in the Ebenezer Baptist Church's Juneteenth bailout program. So they got you out. You don't just say thanks and walk off, but it sounds like they are going to connect you to some resources, and you need to connect yourself to those resources.
Yes, sir.
I will waive your probation supervision fees for the first 6 months while you, like you said, get on your feet and get a job and get heading in the right direction. Okay?
Yes, sir. Yes, sir.
Great. In 24 SC 001824, that is also a case with 4 counts. Is it just a plea to the aggravated assault?
Yes, Judge.
Okay, you're pleading to count 1 and the state is dismissing the other 3 counts. Your sentence as to count 1 is 10 years to serve 2 years with the balance probated. Again, you'll get credit for the more than 2 years you've served. So that's 8 years probation. That's a little longer. Same special conditions that I already stated, plus 1 more. This is where I'm going to tuck in this restitution. You are going to need to pay $427.98, and you pay it as you are able. You don't pay it all at once. You'll pay it bit by bit as you're working, to BINU, B-I-N-U, Kasim, K-A-S-I-M. And that's to fix the damage that you did in May of 23. In January of 25, when you were banging up the door and window again at your mom's place, this time Sunset Avenue. You won't pay that directly to Mr. or Ms. Kasim. You'll pay it to probation and they'll get it to that person. And then there'll be the anger management, the continue to take your medication, participate in the Ebenezer Baptist program. In this case, I'm setting a behavioral incentive date of June 18th of 2028. That means 3 years from now, if you've done well and done everything you needed to do, probation can think about closing out your case early. And finally, in 25 SC 003180, I am sentencing you to 4 months to serve. You did more than 4 months, so you will, that case will be closed out. And that is the case that is now just misdemeanor criminal trespass.
Okay.
All right. Do you have any questions about anything I just described?
No, sir.
Ms. Wood, anything else for Ms. Hamilton?
No, thank you.
Ms. Davis for the state?
No, Judge.
Okay. Ms. Simpson, what do we need to tell Ms. Hamilton about reporting to probation?
Reporting date will be June 23rd at 8.
Okay. Ms. Hamilton, you need to report to probation here in Fulton County on June 23rd, that's next Monday, at 8 a.m. Do you know where probation's office is?
Is it the felony probation?
Yes, on Memorial Drive, just a few blocks from the courthouse. You know where that is?
Right there by the at the ACDC jail.
Right.
Yes.
Okay, as long as you know how to get there. You want to go to the county jail tomorrow to get your meds, and you want to go to felony probation on Monday, 8 a.m. so you can get signed up, okay?
Yes, sir.
Ms. Wood, you'll get You have a way to send her that info as well?
I'm sending it right now, Judge. If we
Great.
could just get her to confirm I wrote down the address, I just wanna make sure that I got it all.
Okay.
So
Can you say the address again where you're staying? Say it slowly, please.
1483 Arthur Langford Junior Place, Southwest, Atlanta, Georgia 30315, and that's building 9, apartment 4.
thank you.
Good. All right, Ms. Hamilton, do us right. Take your medication, go to your classes, and hopefully this is something that works out, okay?
Yes, sir. Thank you.
You're welcome. All right, we are going to be on break till 1 o'clock, when we will do a probation revocation and a plea, but I don't think those involve Ms. Rios or Ms. Wood. It's a private attorney for the revocation, and it's Mr. Shart, another private attorney, for the plea. So I will mute this, and I sent Better now that you're here. Your timing is good because we're supposed to be doing a probation revocation hearing, evidentiary hearing, but I think we've got an officer who's stuck in traffic, which means we can handle Mr. Elder's situation right away if Mr. Elder's here. And I see him. So why don't you just get oriented and ready, but we can do it.
Okay, can I have 2 minutes?
You can. I'm gonna be right here.
Excellent.
I'll be right back, but I will be here.
One thing a night. Some college, you can work with film. What's your title? What do you do? Serious or something started. Okay, what are your goals? So, okay. You think that goes forward? And you're seeing it's like that for example. Where is that a private psychiatrist? What? Southern. Yes. And the only 2 arrests were your life are the father. Doing it. Yeah.
Glenn, have you had a chance to speak with Mr. Lemons?
Yes, I did speak to them brief last night.
Okay, I didn't know if you needed to huddle with him now before we get started.
I will.
Okay.
Just, we talk out. I just want to make sure that he's clear with his decision.
Great. When we're in the midst of the plea, if we've got 2 deputies in here, maybe they can get you back there to talk with Mr. Lemons. You think? Great, thank you.
I need to I took a 10 probation and I thought. And then I'll say 10P and then you can, it's a quasi negotiated. Yeah. Just now. And we're asking for first. I don't have an objection to it. Yeah.
All right, are we ready? Yes, sir. Great. Mr. Elder, you should come on up with Mr. Sharp. Stand at the podium there. Please.
Sure. The only thing I haven't seen, Your Honor, is the indictment.
You will not see it. We do electronic signatures now, but I'm gonna pull the case up so that I've got it in front of me. If it's essential that you all look at it, I don't mean to deprive you of that.
No, I just wanted to sign it beforehand. If
Yeah,
that's
we
what-
flow a little differently now. Ms. Nelson does the e-signing. Once I get on the record that everyone agrees it's okay to have her electronically signed. So if there's an objection to that, then I'll go very slowly, print it out, and
There will
we'll
be no
wait for the,
objection.
okay. 6350, let me get the case up. All right, Ms. Rivers, you ready? Great. We are going to get started. This is case 24 SC 006350, State versus Justin Elder. Mr. Elder is here in court with his lawyer, Mr. Shart. Ms. Davis is the prosecutor handling the case. The indictment charges 2 counts of aggravated assault, 1 count of criminal damage to property, 2nd degree, and finally, a count of possession of a firearm during the commission of a felony. Mr. Elder, Mr. Shart told me a few days ago that you were ready to enter a plea. We just needed to get everyone here into court at a time that worked, which is 1:22 on Tuesday, the 17th. Are you ready to go forward?
Yes, sir.
Okay. Ms. Davis is going to put you under oath in just a moment. Once you're under oath, you'll need to answer her questions truthfully and completely. And I need you to promise me that if you've got questions of your own, you'll let me know or Mr. Shart so we can address those. Will you do that?
Yes, sir.
Great.
And Your Honor, just so you know, this is going to be a non-negotiated plea.
Non-negotiated plea? Okay. What that means, Mr. Elder, I'm sure your lawyer told you, but I want to see where we are in the process. It probably means 2 things. It does. So first, Ms. Davis is going to recommend something different, presumably higher, meaning more probation or more fine or more jail time than what Mr. Shart recommends. Second thing, because you still have your final plea rights in place, I will impose whatever sentence I impose. I'm not bound by either recommendation. If the sentence I impose is materially different from what Mr. Shart asked for, then you'll have a chance to talk with him and let me know it's not exactly what I asked for, Judge, but I'll go with it. Or, you know what, I was comfortable with what Mr. Shart asked for. I'm not comfortable, you don't have to use these words, your sentence, Judge, so I'm withdrawing my plea. No questions asked. You don't have to check a particular box. You can just say, nope, that's not what I thought was going to happen here. And then we'll get you onto a trial calendar, which it looks like you are already on. And so I'll see you for trial if we don't work it out today. Does that make sense?
Yes, sir.
All right, Ms. Davis?
Mr. Elder, please raise your right hand. Do you swear or affirm the testimony you shall give in the matter before the court shall be the whole truth and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true and correct legal name.
Justin Elder,
Okay, please spell your last name for the record.
ELDER.
Are you at this time under the influence of any alcohol, drugs, or medication?
Take medication.
What do you take medication for?
I I take medication.
Well, let me ask this. It's actually none of my business what you take it for, but the medication that you take, is it something that makes you woozy or dizzy or confused when you take it?
No.
Does the medication address any mental health condition that, if untreated, makes it hard for you to understand what's going on in court?
Yes.
Okay. Do you feel like the medication is helping you understand what's going on in court?
Yes.
All right. If you have any questions about what we're doing, you'll let me know.
Yes.
Mr. Elder, how old are you and how far have you gone in school?
36 and some college, graduated high school, did some college.
Okay, where did you attend high school?
Frederick Douglass, high school in Atlanta.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you are charged with the following offenses in indictment 24 SC 006350? Aggravated assault for count 1, count 2, aggravated assault, count 3, criminal damage to property, and count 4, possession of a firearm during the commission of a felony.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Sharp?
Yes.
Okay. Have you discussed all the facts and circumstances known to you regarding the charges and the indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes.
Mr. Sharp, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
So waived.
Mr. Elder, do you remember being arrested on these charges?
Yes.
Judge, the state is unaware of any outstanding warrants related to this matter. Mr. Sharp, are you aware of any outstanding warrants related to this case?
I am not.
Mr. Elder, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading today?
Yes.
For aggravated assault, I believe the maximum sentence is 20 years. For criminal damage to property, I believe it is 5 years. Possession of a firearm during the commission of a felony is 5 years consecutive, which means afterwards. That's the maximum.
Gotcha.
Do you understand?
Yes.
Okay. Do you understand that if you plead guilty or enter a blind plea, also known as a non-negotiated plea, the state will still recommend a sentence to the court?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that do you understand that this guilty plea will be permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, to hold public office, the right to serve in a jury, the right to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself, the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Okay, how do you plead to the charges in indictment 24 SC 006350? To,
Oh, sorry.
okay, well, that's good, I understand. To all counts, aggravated assault, count 1, aggravated assault, count 2, criminal damage to property, and possession of a firearm during the commission of a felony.
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
Is this plea freely and voluntarily given with the full knowledge of charges against you?
Yes, ma'am.
Your Honor, at this time, we believe that the state would prove at trial that on August 15, 2023, at 3178 Peachtree Road in Atlanta, Georgia, in Fulton County, this is also known as Essex, ESSEX jewelry, that the Atlanta Police Department was responding to a dispute call at the fine jewelry place. The victim stated that Mr. Elder came into the location about 10:30, arguing about a watch that he had ordered, and that he pointed a gun at Mr. Solomon Robinson, stating, "I'm not afraid of you. I don't even need my gun." He also broke a counter space that displayed jewelry and a chair, and officers responded to the scene and arrested Mr. Elder. The state's recommendation.
So based on what you understand the evidence to be, Mr. Elder was still in the store when the police got there and they took him into custody. He had a gun and there was a busted counter.
Yes.
Okay.
And chair.
Okay.
The state is recommending 10 years probation. We are requesting that Mr. Elder continue mental health treatment and any medication as required by his provider, that he complete an anger management course, that he pay $500 for restitution for the damages done to Essex Fine Jewelry, and that he remain gainfully employed since he does have a high school degree.
Okay. And some college.
In college.
Okay. I got that. Ms. Jackson, good afternoon.
Good afternoon, Your Honor.
Do you have any criminal history information for Mr. Elder?
There are no prior arrests, Your Honor.
All right. Thank you so much. And I think that's it for you today. My sense is that, well, actually, if you don't mind sticking around, just in case Mr. Lemons wants to resolve his, well, does he have new charges? And the new charges are the basis for the revocation?
Correct.
Okay.
The charges are before us.
Yeah. So if you don't mind sticking around, if we get into the revocation hearing, you should peel off and go do all the many other things you need to do. But stranger things have happened. So he may come out here and say, you know what, I just want to resolve everything. And then it would be very helpful to have you around.
No problem, Your Honor.
Thanks. Okay. Mr. Sharp.
Thank you, Your Honor. May it please the court. I'm a big fan of Justin Elder, not just because
he hired you,
not just because he hired me, but because, you know, he's really why we do this work. Mr. Elder had some issues going on and that I'm going to get into, but I think, as I hope to convey to the court, he's addressed these issues and has turned things around. First of all, you know, he's 36 years of age and he is absolutely blessed and he realizes this. He's blessed with family support. His mother's back there. His father's been at court dates supporting him as well.
Does he live with family or they are just local and help out when help is needed?
He did live with family. I don't believe he's living with family now, but he was living with family. I'm going to talk to you a little bit if assuming Your Honor will allow me eventually to talk about what was going on around 2020. And he really leaned on family around that time. He's a father of two. You know that he's graduated high school. He grew up just like any of us and you know, went to school and had dreams, and he got involved in the film industry. He's a set lighting tech. So when Georgia started attracting the film industry, he was very involved. He was gainfully employed. Fast forward to 2020, just probably, to be more accurate, around 2018, as tends to happen with men, some men in their 20s, late 20s, mental health started creeping in. He had a mental health diagnosis. He's schizoaffective disorder, bipolar. And the bottom line is in 2020, a couple things happened. We all became socially isolated to some extent, and the film industry shut down here. And that was very tough on him. He had his mental health. He wasn't getting treatment for his mental health at that point. And things were kind of spiraling out of control. His marriage broke down. He was married before. His marriage broke down during this time as well. So just to correct a couple things, to be honest with the court, he does have at least one other prior arrest. And these are all around this time frame. He was arrested for fighting with his father when his father actually called the police to try to get him some help. And he was arrested for hitting his father with an object. This situation, from my understanding, Your Honor.
This situation meaning the jewelry store or
Yes.
the father's situation?
No, I just wanted to clear up that he does have and he received PTI for that. I represent him on that.
Okay.
And he
You
received
know you were
PTI.
there for
Yes.
the court?
Yeah.
It was a felony case?
No, that was a misdemeanor.
Okay.
And also, Your Honor, we had this situation. Obviously, a mental health defense, there was mental health involved. My understanding of what happened in this case is Mr. Elder was confused in his mental health. He entered some sort of business deal that he can't really fully understand why he would have entered at this point, but it involved selling this watch to get money to pay this other man to become business partners with, really, when you think about it now, a business that didn't make any sense. And the other person backed out of this deal, and he became convinced in his mind that the store was in cahoots with this other individual.
Because they wanted the watch.
Because they wanted the watch. And
what kind of watch is this?
It was a nice watch, I believe.
It was a Rolex Sky Dweller.
Where did you get that?
I bought it at another jewelry store in Buckhead.
With money earned from the film industry?
Yes, sir.
When times were good?
When times were good.
Okay, and so it represented a fair amount of money that you could then sell to a jewelry store to pull that cash back,
To
invest in whatever this
Yes, sir.
deal wasn't.
That's what happened, and it just went all wrong, and I wasn't really thinking right. Like he said, the catalyst for this was when my family broke up.
Family meaning your wife and
Wife and kids.
your nuclear family. Okay.
We have a 15-year-old son together. Been together since high school.
You and his mom had been together since high school.
Yes.
You can let Mr. Sharp tell the story if he knows it. You don't have to do the talking.
Get it out.
Okay.
We were married for like 6 years. Had a brand new house together. Ended up staying there for a little while. I sold it, bought another brand new house, got it built. 3 months into that, she cheated. So separated. And things just kind of went downhill from there. It's like, I'm not no troublemaker. I never, I always just been work, take care of the family. And when that went off, things just got out of hand. And since then, like my family's been there. Even when times that I didn't know I had a problem. I didn't know, until I actually started getting in trouble. And it's just back to back. And I'm at home talking to myself and just seeing things that weren't there. And they finally got me help. I did some inpatient for 30 days. And, they helped me to realize I had a problem. I got on medication. Once I'd been on medication, it kind of just hit me. Like, do you realize, like, all this stuff that happened? Like, And ever since then, I got out. I've been back working, back to work.
What kind of work are you doing now?
Still in film.
Okay.
And yeah, like from the month that I got out, my coworkers, they knew I was going through some things. They kind of embraced me back after I got my help. And I just been working since,
Are your kids present in your life?
Yes, I
Good.
see them every day.
Good. Their mom is living her life, but you're able to see your kids. Okay.
They actually live like 5 minutes from me.
Okay. Good. How old? You mentioned you have a 15-year-old.
My son's 15, my daughter's 7.
Okay.
So, and thank you, Justin, for that. So essentially what happened is throughout these, there was clearly a problem, and his family was able to get him into Southern Live Oak Wellness, where he did a 30-day inpatient. And since this time, he's been seeing a psychiatrist, receiving medication, been clear-minded, been doing very well. I made sure that I asked about this because I think it's a relevant question, making sure that there's no firearms around when he's struggling for mental health or was struggling, and there's no firearms in the house or anything like that anymore. And he's just been doing really well, and he's getting back to work and putting things together again. So yeah, I mean, this is who he is, and he feels blessed, but is ready also to turn the page. The state has requested 10 years probation, and I understand that. I understand that this was certainly would have been a scary situation if I was in that store, but at the same time, and just so your honor knows, I did recommend Mr. Elder for behavioral health treatment court, but they actually determined from what they told me that because he was in treatment and doing so well, that he wasn't really their target anymore.
He may be high needs, but he's not high risk right now because he is managing through the help of medication and therapy and whatnot, his conditions.
So, I'm glad he's doing well. I was just surprised that he was doing too well, that he couldn't avail himself to those services, but he was interested in that. But I think that this it's certainly something that he wishes to take responsibility for, with the understanding that there was mental health involved. I'm going to ask your honor, first of all, to consider sentencing him as a first offender. He is eligible. And also, your honor, I would ask that you would consider a 3-year probated sentence in this matter.
Got it. Ms. Davis, were you able, or someone on your team able to contact either Mr. Latson or Mr. Robinson to see their perspective on how this should play out?
Oh, yes, Judge, I did speak with them. That's how I was able to obtain the restitution amount, but they knew that it was a mental health issue. And so their only concern was for him to get help. And that's why my offer was a probated sentence.
Got it. So it has their input and really their seal of approval. And somehow the restitution just comes out to 500, or they said it's more than that?
Yeah,
but
it says more than that, but they would accept.
500.
Yeah.
Okay. It was just an awfully round number for what was
Very
described.
convenient number.
But it rounded down, which is to Mr. Elder's benefit. Okay. Thank you for that.
And just for the record, I discussed that with Mr. Elder, and he thought it would be more. So
Maybe another zero attached.
So he was okay with that amount,
Okay.
and we're fine with that.
Okay. Got it. All right. Mr. Shart, do you authorize someone in my office to sign the indictment electronically on your behalf?
I do.
Ms. Davis, can we do that for you?
Yes, Judge.
And Mr. Elder, is it okay if we electronically sign your name indicating your guilty plea on the indictment?
Yes, sir.
All right. Ms. Davis, first offender hadn't come up when you were talking and I was asking you questions. Mr. Shart has asked for that. What's the state's position on that?
I don't have an objection to that.
Okay. Mr. Elder, first offender is something you qualify for. That means you don't already have a felony conviction. It's primarily an opportunity. It means that if I sentence you as a first offender, even though you're under sentence, you do not have a conviction. So you don't have to suddenly report to work and say, hey, I need to let you know I'm a convicted felon. If you decide to go back to college, you don't have to check that box that says I'm a convicted felon. If you apply for other jobs, you don't have to check the box that says convicted felon because you're not. And if you successfully complete your sentence, you remain not a felon and you can have it all expunged at the appropriate time. That's the benefit. It does carry a risk. And that risk is if you, for whatever reason, stop taking care of yourself, go off the medications, don't get the therapy, and start succumbing to some of what you were working through in 22, 23, even though that might explain what's going on in your life, it will not excuse that conduct. And if you're arrested again, for example, pulling a gun on someone, you'll have a new case. But you'll also come back here and you'll have a hearing. Mr. Shard will be here. But if I find that you let things slip and it was something that you ought to be held liable for, I can resentence you. So it's not just a revocation, but I revoke your first offender. And there's some big numbers involved in this case. 50 years, 20 plus 20 plus 10. I'm not saying I'd revoke 50 years, but I am saying, and you need to hear this clearly, that if we're together again in a year or 18 months or 6 months, and you got arrested and it involved you pulling a gun on someone or having a gun, or just doing something that you know when you're taking care of yourself is the wrong thing to do, we'll probably be talking about revoking your first offender and resentencing. And Mr. Shark can still put his arm around you and say, I really like Mr. Elder, but it's going to be a different setting. It's going to be one where I believe you knew better and you chose not to take care of yourself. You know, this first time around, you were experiencing it for the first time and you're not quite sure what's happening to me. You hadn't benefited from family help and professional help, but now you have, and you know what you need to do to keep that at bay. And if you choose not to do that and you get in trouble again, then there'll be consequences that'll take you out of commission for a while. And I just need to make sure you understand that first offender mostly is an uplifting thing, but there's a trap door in it and the fall from it is pretty far because you will have not lived up to your commitment, which is, you know what, this was my one-time mess up and I'm not going to ever do something like this again. And first offender is perfectly appropriate for someone like you. You just need to tell me you understand the risk that's involved so that when we come back, if we do come back, and I hope we don't, you don't say, well, wait, what are you talking about? Sentencing me to 15 years because I pulled a gun on someone again. And that's not for the new charges. That's for this, because I'll have decided it's not safe. It is not safe for you to be out and about because you stop taking the meds and then you hear something and you're like, I'm going to go try to get my watch back or whatever it is you do. You can go do something to your kid's mom. And we need to, of course, keep everyone, including you, safe. And we all read all too often what happens when someone is in a moment of mental health crisis and has a weapon and law enforcement gets involved and they say, put that gun down, and you don't, and you head towards them. We don't have a case anymore. We have a casket. And so there are all sorts of reasons why you need to be real careful about this. Do you think you understand how first offender works?
Yes.
Okay.
I understand the benefits and the seriousness of it.
Okay.
Don't do right.
And you think that first offender makes sense for you?
Yes.
Okay. All right. Well, Mr. Elder, I find there's a factual basis for your plea. It sounds pretty clear to me what happened in August of 2023, and that while it was physically you, it might not have been mentally the Mr. Elder who's right here right now, but it was you. I suspect those two men were pretty scared when that was going down, and you got pretty rough in there breaking the stuff up. Fortunately, no one pulled any trigger. And of course, they could have been the ones pulling the trigger, and it's, hey, we're just defending our property, and you've got a real sad family and no recourse. So factual basis, I find. I also find that your plea is knowing and voluntary. Voluntary meaning no one's forcing you to enter this plea, and knowing meaning that you've understood the things we talked about. Do you agree with that?
Yes, sir.
All right. I'm sentencing you pursuant to the Probation Options Management Act, which means simply that while you're on probation, If you have a minor violation, you miss a meeting or something like that, you and probation will solve that. You don't have to come see me. But if you get arrested or it's anything serious like that, that comes back in front of me, and then we go down that path that you don't want to go down. I will sentence you as a first offender. I think that is appropriate for you, your circumstances, and this case. So looking at your indictment. Oops, wrong case. Here we are. On count 1, I am sentencing you to 1 year. Count 2 is 1 year, and count 3 is 1 year. Those will all run concurrently with each other. Count 4 has to run consecutive and has to be 5 years. So it's a total sentence of 6 years. I am probating all 6 years, so it's 6 years probation. Special condition number 1 is that you maintain your mental health treatment to include both medication and counseling, therapy, whatever we call it. If you're meeting with a medical professional, you continue to do that at whatever cadence that doctor says. If it's once a week, once a month, 3 times a day, whatever that doctor's telling you. And you don't get off the medication without a doctor saying, oh, you know what, we're going to switch this one up because these side effects aren't so good, or we can taper this one a bit. Doctor's orders are my orders, okay? Number 2, you will enroll in and complete an anger management course. 3, you'll pay $500 restitution. That will be payable to Essex Jewelry. You don't go back there. You don't pay them anything. You'll be paying probation. They'll get the money to Essex Jewelry. 4, you're going to stay away from Essex Jewelry. Even though they may still have your watch, someone else would need to go get that watch. You don't ever set foot in that jewelry store. And then finally, that you maintain gainful employment, or you're a full-time student. So if you go back to college, then you don't need to be working. If you're not in college, then you should be working. I will request, I can't order it, but I will request that Department of Community Supervision, that's probation, that they assign to you what we call a mental health probation officer. That's someone who is trained in being attuned to the needs you might have, making sure you're taking your medication, knowing what that medication is and what side effects are, and getting a sense of whether you're not taking it, and just being more supportive in that space. So I hope they do that. I just can't command them to do that. Finally, I will set a behavioral incentive date of June 18th of 2028. What that means is if 3 years from now, you've done everything we're all hoping you'll do, you've paid the restitution, you're staying on your medications, you're working hard, all that. If probation says things have been going well, then you and Mr. Sharp can say, let's close this out early. And if things have gone well, that's probably what I'll do, because probation has folks who are a real pain in the rear to supervise. And if you are not being that way, why do they need to be bugging you? Because you're not bugging them. But that just means you need to be available for them when they need to talk to you. You do all the things that they need you to do. I think I covered everything. Mr. Sharp, anything else on behalf of Mr. Elder?
No, Your Honor.
Ms. Davis, anything on behalf of the state?
No, Your Honor.
So, Mr. Elder, do you have any questions for me?
No, sir.
The sentence that I imposed is actually double what Mr. Sharp asked for. It's less than what the state asked for. Unsurprisingly, I'm somewhere in between. So you and Mr. Sharp should talk, because you, like I told you at the outset, have the ability to say, you know what? I was willing to do the 3 years probation, but not more. And so I'd rather go to trial. So why don't you guys talk, and then Mr. Sharp can let me know what you want to do. What's the word?
We have conferred, and Mr. Elder wishes to accept the court's sentence.
Okay. Tell me what county you live in.
Fulton.
All right. Ms. Simpson, who is seated right there in the jury box, is with probation. She will not be your probation officer, but she is right now your probation guide. So chat with her. She's going to give you reporting instructions. And if she doesn't already have your contact information, she's going to need to get that so she can get it into their system. And you do not want to miss that first day where you report to probation. It's about 2 blocks from here. She's going to give you the address, but that's maybe the only time you have to show up in person. There may be more, but you will definitely need to be there for that. Otherwise, you started out on the wrong foot because they're going to take out a warrant saying, where's this elder guy? So make sure you make that first meeting, okay? Okay. All right, good luck.
Thank you, Your Honor.
You're welcome.
And Your Honor, once we're, meet with probation, we may be.
You are good to go. Is Mr. Glenn still back with his client? Okay.
You're doing nice shit. Appreciate you. It's your office.
Yeah, it's my officer.
Okay.
Page 7 to take them off.
You decided not to?
Yeah. Okay. It's fair.
Yeah, no, you will.
I think he was.
All right.
Um,
You need anything?
no, not yet.
Okay.
Sure.
Okay.
Probably struggled during it, but that's fine. I print off my pictures.
Okay.
I know you can do it electronic. I just need to get paid off first.
Okay.
He may get me.
Oh, yeah, you might. Well.
I just read this. And I didn't do all, it was 127 photos. So
Okay.
I did the whole offense. And this is the image of the defendant.
You want me to scan those?
Hmm?
Let me scan those?
Yeah, film evidence. I have them.
Oh, okay.
Yeah, if I had to, I will. This is his girlfriend's or whatever fiance's truck, the tires that were stolen. Closer of the tag, the registration was found. And then this is like their comparison of who he is and the image there. And they did did a search warrant on the phone of my dad, but they didn't exactly, I didn't see it in the police report, but they took out search warrants for
The phone's in the car.
the phones in the car and the phones of the people that they arrested at the scene, just 2 people. And then they had 2 IDs that were located in a U-Haul, unrelated to my defendant.
Ms. Davis, are you ready for the Lemons revocation hearing?
I am.
All right, Mr. Glenn, you ready?
I am ready, Your Honor.
Great, let's bring Mr. Lemons out. Mr. Glenn, you can take over council table over there.
Do it here if I can, just in case. You can go, in real time.
I'm done, but if it allows you to do it at this point. Okay, all right.
Judge, would you prefer me at the podium or may I be seated? How would you like me to?
Oh, as long as the witness can hear you, you're welcome to be seated. That's fine, however you want to do it. I do need, let me look here. Does anyone have a copy of the warrant or the petition?
You know, I do, Judge. I have a copy of the warrant.
Ms. Davis usually has like 10 copies of each thing, so.
I have a copy of the warrant.
Excellent. Have that. Thank you. Sometimes they're attached to the calendar, but,
Oh, I already handed it.
okay. Ms. Rivers, are you ready?
Ready.
Great. We're going to get on the record. This is 14 SC 131165, State versus Lemons. Mr. Lemons is here in court with his lawyer, Mr. Glenn. Ms. Davis is representing the state. Good afternoon, Mr. Lemons. Good to see you. Still don't like seeing you in that blue outfit. But here we are. Mr. Lemons, you are on probation in the 14 SC case. You have just under 3.5 years remaining. So you got a long old sentence for that one. But according to Ms. Simpson, who's with probation, you got 3 years, 5 months, and a little bit left remaining on probation in your 14 SC case. Judge Krause, who is my colleague on the other drug court, signed a probation warrant in that case in January of this year. And the allegation in that probation warrant is that back in July of 2023, you committed new offenses of burglary in the second degree in Fulton County. And I think this relates to the CSX rail thing, but I'm gonna find out. The important thing is this: you're on probation in this old case from 2014. There's still a bunch of time left, and you were arrested in 2023 for new charges. And that is a basis to have your probation revoked. We had a mini hearing a few weeks ago, maybe a month ago, where your lawyer and you conferred. And what your lawyer told me was that you are contesting this violation, which you're free to do. The state has to prove it up. And so we're going to have a mini trial. It's a bench trial. There won't be jurors here. And the state's burden of proof is actually much lower at a revocation hearing. They need to prove up this allegation that you were arrested for burglary in the second degree, actually that you committed burglary in the second degree, by a preponderance of the evidence, meaning it's more likely than not that you did what you're accused of. If you end up going to trial, it's reasonable doubt. That's a much higher burden. We'd have a jury, all that kind of stuff. So I'm going to hear testimony from an officer or a detective in a few moments. We'll find out who this is in just a sec. The prosecutor will ask questions. Your lawyer will ask questions. They'll make argument. And then I'm going to let you all know if I find that the state met its burden to prove by a preponderance that you committed either directly or you were party to a crime to these second degree burglaries back in July of 2023. If I find the state did not meet its burden, then this warrant is set aside. So if that's the only thing holding you in jail, then you get out of jail. You still have these new charges, the case that you've got with me and some other defendants, but this warrant gets set aside. If I find that the state met its burden, then we shift to, well, what's the consequence of you having committed these second degree burglaries? And the state will say, Judge, you should revoke. And they're going to say some number that is 3 years and 5 months or less. And your lawyer will say probably a number less than what the state asked for. Because if you actually agreed on it, we wouldn't be having this hearing. But clearly there's a disagreement. So that's the plan. Any questions about that? Okay. Mr. Glenn, any procedural matters we need to take up, or are you ready?
None that I'm aware of, beyond this time, I think we're ready.
Okay, then.
That you want publishing.
Okay.
So if they prefer to publish via Zoom or physical.
Judge, just a bit of housekeeping. I'm going to be presenting to the court some photo evidence. Would you like that photo evidence to be published via Zoom?
Through this witness?
Yes, Judge.
Yeah, that's typically the way I like it, because that instead of like carrying it around, Mr. Glenn and Mr. Lemons will be able to see it. Ms. Rivers can see it on the screen there. So we just use the share feature in Zoom Room. So one of those two laptops just needs to be in the Zoom call.
Okay.
So maybe your trial partner can be working on that.
Yeah. Judge.
All right.
I'm going to share this Zoom link.
I can log on. I need just some photos just in case. Okay. Thank you, Judge. We're ready.
Okay. Then why don't you call your first witness, please, who may already be on the stand?
Judge, we would like to call Officer Christopher Vaughn to the stand.
All right, if you'd stand first and get sworn in.
You swear affirm that the testimony you will give the truth, the whole truth, nothing but the truth? Yes. Can you state and spell your name for the record?
Christopher Vaughn.
Can you spell your last name, please?
V as in Victor, Vaughn.
Mr. Vaughn, where are you currently employed?
CSX Railroad Police Department,
And what is your official title?
Special Agent 3.
What does a Special Agent 3 do?
We investigate high-end cargo thefts, do a lot of other things. We investigate terrorist activities on railroad tracks, also investigate fatalities, car versus person, train versus car type accidents.
Train usually wins.
Yes.
Are there a lot of terrorism cases that you've had? I don't read a lot about train terrorism.
It's usually people trying to derail trains purpose, so
okay,
type of stuff. But
and can a CSX railroad special agent arrest someone?
yes, we have state powers. Also, we have a commission. When we have federal jurisdiction, we can go outside of our state to make arrests so long as it has a railroad nexus to it. So,
but if you saw me run a red light in Powder Springs, could you pull me over, or it would only be if I illegally cross railroad tracks in Powder Springs?
Technically, we could. We have the same powers as local sheriff or state patrol.
Okay, but it's statewide.
Yes.
Okay.
So I guess that would mean, are you post-certified?
I am post certified. I also hold a commission from the governor's office as well.
Okay. Were you post-certified on the date of this incident that we're here for?
Yes, ma'am.
And the date of that incident would have been in July of 2023.
Yes.
How long have you been with CSX?
About 16 years. Yep.
I want to draw the court's attention to the date or dates of this incident. Can you describe the incident that I guess alerted you to your investigation on the 3rd? Can you describe what happened on July 3rd of 2023 or 4th, excuse me?
Yeah, so we were receiving,
23 on July 4th. I said July 3rd at first. Yeah, July 4th, 4th of July in 2023.
so we were receiving a rash of burglaries coming from the Atlanta Halsey Yard. The Atlanta Halsey Yard backs up to, I believe it's 350 Decatur Street. There's a pencil factory loft apartments. So if you go behind the apartments, our yard is back there. And of course, there's a large hole in the fence where subjects will go in and out, trespassing on railroad property. And oftentimes they use that for burglary routes too, to break into our trains. With the large amount of burglaries that was taking place, I was tasked, I put up surveillance cameras in the area. So we have multiple surveillance cameras in the area. And these surveillance cameras, they have cellular triggers on them. So as soon as someone appears on the camera, it alerts us and let us know someone's out there. Well, that night, we received an alert that multiple subjects were coming through our yard through that hole in the fence where we had the camera set up. So we came out there the first night. We weren't able to get anybody, but they all fled the scene. But we captured multiple subjects on our video camera.
Any reason you didn't just fill the hole up?
Well, we close it, but they cut another one in there. So
Okay, it's inevitable, sort of cat and mouse. We close this hole, they make another hole.
Right, or they'll just cut that one open, but I believe the fence has been repaired at this time, but I'm suspecting that at some point they're gonna cut another hole in the fence. Because people just don't want to walk around. They want to just cut right through the yard and get to the other side, but that also presents an opportunity for burglars.
Oh, some people use the hole on the fence just as a passage to get to Decatur.
Yes.
As opposed to go over to a cargo container or a rail car and take some whatever's on it.
Right.
Good.
Okay. So.
Officer Vaughn, I'm just going to pause you right there. I just want to make sure that we address where this incident occurred on July 4th. What was the address, this location?
The address is 171 Boulevard, which is the Atlanta Halsey Yard. The actual, we use like 350 Decatur Street, which is that backs up to the yard. And where the incident actually happened is technically it's the whole yard of 171 Boulevard is the location of the Halsey Yard. But that particular hole in the fence is right there behind 350 Decatur Street. So technically it would be 171 or 173 Boulevard, I'm sorry. It would be the actual location of the Atlanta Halsey Yard.
And what is Halsey Yard? Can you describe what is that location? What is at that location?
Atlanta Halsey Yard is a yard where we store containers. It's where trains come into and they wait at that location before going out to their final destination. So they're parked there, recrew. Sometimes they'll hook up other containers and take them to another location before they usually go from Halsey down to the Fairburn Yard. So the Halsey Yard is huge. I mean, it sits in two counties, Fulton and DeKalb County. So it crosses over Moreland Avenue as well. All down DeKalb Avenue, that rail yard is all that is part of Halsey Yard.
Can we see a portion of Halsey Yard across the interstate? 7585, is that part of it?
Yes, can.
How many containers does that yard hold, or approximately?
It can hold, I would say, I don't know how many containers actually, but as far as trains, it can hold up to maybe about a 4,000 foot train. It can hold up to at least that much, a 4,000 foot train. So, and that's an average train. Some of them get up to 5,000 feet.
Okay.
So.
And going back to the date of July 4th, can you tell us about what you did on that date, how you started your shift?
Well, we started our shift earlier that day. We put up cameras during the daytime because we knew they were coming out at night. So we spent most of the day putting up cameras and just getting everything set up. So, and like I said, later on, early that late night, early morning, is when we started getting the triggers. And you can literally see subjects on the video of the cell phone video. You can see them coming into the yard. So as they were making their way in the yard, we had Atlanta police, ourselves en route to the location. I think it was maybe the second night when we ended up catching 2 or 3 individuals that night.
So do I go first or do I just go? Okay. Judge, may I approach the witness?
Sure. If you've got a bunch of exhibits, my request would be you put them all up there and then you can have him, hey, now look at number 7, look at number 6. So you don't have to keep going back and forth.
You're fine.
Thank you. Judge, I asked that the record reflect that I have shown defense counsel what has been marked as state's exhibits 1 through 5.
Okay,
May I approach the witness?
you may. Both sides have continuing authority to approach the witness during their examinations.
Okay.
Officer Vaughn, I'm going to ask that you take a look at the items that I showed you on approach. Do you know what those items are?
Yes, ma'am, I do.
Does it appear to be what it purports to be? Does it look like there's been any changes or additions to those photos that you were shown?
No.
Are those photos from, I guess they are from different sources. Are some of them from the surveillance cameras?
Some of them are from our cameras and some of them are from the apartment complex, the 350 Decatur Street Pencil Factory Loft security cameras.
Okay, and they share that footage with you during your investigation?
They did, yes.
Okay.
That's also mentioned in a report as well.
All right, Judge, I would ask that the state's exhibits 1 through 5 be admitted into evidence.
Mr. Glenn, any objection to the admission of states 1 through 5 for the purposes of the revocation hearing?
Yes, I do have an objection. As I observed with the photographs there, it appeared to be footage from a video camera that was time-stamped, and there were also photos actually of Mr. Lemon taken independently, weren't taken the night in question at all. They're just basically pictures of him. I would object to the extent that the pictures would depict the person in the video. The video either speaks for itself or it doesn't. If there's not quality there, then the picture shouldn't, the picture would not, my objection is the picture would not demonstrate that picture is the person in the video.
Got it. Okay. I think I understand your concern. I'm going to admit states 1 through 5. We'll see what the testimony is about them, but I think a sufficient foundation has been laid that they fairly and accurately depict the images that were taken. Now, if this witness starts saying, well, I think in this picture is X or Y or Z, you'll be able to follow up to say, how can you say that's what it is? And you may have specific concerns about that testimony, but for this hearing, I'll admit states 1 through 5.
Understood,
Officer Vaughn, on July 4th, did you notice there were any containers that had been disturbed?
Yes, there were numerous containers that have been broken into, yes.
And how can you tell a container has been tampered with?
Well, the containers are, believe it or not, they're locked with a bolt seal. A bolt seal is like a steel bolt that goes down into the loop of the lock of the handle locks. And there's another piece of the seal that's pushed into it that locks it in place. And most of the time, that's what containers are usually, that's their security. There are more advanced seals, like warlocks that are put on containers, but usually they're not, you don't see those unless the customer pays for them. They're like $200 a piece. So if you're a customer and they have like 1,000 containers, that can add up. So, but the bolt seals are free. So that's usually what the railroad puts on there as a security method. So.
And you said the bolt seal is made of steel.
Made of steel. But what they do is they take bolt cutters, and bolt cutters can easily just cut right through them. And once they cut through them, they just fall apart. And then that's how they take get into the containers, and they open the container doors and breach the container.
And when we're talking about a container, it's not a rail car, like a box car, but this is the basically what you'd think of an 18-wheeler hauling. Or is it like a shipping container, the big metal box that would be lifted from, those don't go on trains. What do you mean by container?
So there's two types. There's trailers on flat cars. Trailers on flat cars are you see your tractor trailers with the wheels on it.
Right.
Oftentimes you'll see Norfolk Southern, their trains, they'll have like these tractor trailer trailers on there with the wheels on them. And then that's called a trailer on a flat car that has wheels. Container on a flat car has no wheels.
Okay.
It's a big square metal container, and it sits flat on top of a metal car.
Yep.
And that metal car has the big steel railroad wheels on it.
Mhm.
So when those are lifted off, and once it enters into an intermodal yard, a crane will pick that metal container up and then put it onto something called a hostler truck. Hostler truck is just a truck with a little short front, but has a long back and it's flat. And sits it right on top of it, and then they'll go park it for the customer. So containers have no wheels, trailers have at least some wheels.
Got it. And here we're talking about containers. So it's a big metal box.
Big metal box.
Okay. And is it the type of container that you see stacked on these boats coming across the ocean that then make it onto rail, or it's a different type of container?
Exactly what it is.
Okay. Got it. And that's where there's this, whatever you call the steel bolt that can be cut.
Right.
Okay.
About how many containers were broken into on July 4th?
I had my report to see. I know there were multiple containers broken into, but we basically charged them for the containers where items were taken out of. Because for every container, it's like a second degree burglary. But usually we'll have them where they'll break into multiple containers. But if there's nothing taken out, we normally would just charge for what was stolen out of whatever the containers we have that had items taken out of is what we charge them for. So, it just depends on the agent, what they want to charge them with.
Okay.
So,
What items were stolen on the 4th of July?
So we had some tires that were stolen. They were high-end tires for cars. We also had industrial fans that were taken. And also, I believe it was some industrial type microwaves, countertop microwaves that were taken. So those items by itself with the tires, the industrial fans and microwaves, I think there were over $100,000 worth of stuff that was taken. They were pretty high-end materials. Everything else was pretty much bulk material that they really couldn't carry out unless they had a tractor trailer truck or something to load it into. But
So did the surveillance footage just show these guys taking microwave after microwave through the hole in the fence, or these were fancy enough that one tire, one microwave, and one fan got you to 100,000?
no, it shows them making multiple trips.
Okay.
And loading these tires into this white truck. See here.
On the other side of the fence.
On the other side of the fence, they parked in the parking lot of the pencil factory lofts.
Okay.
And they came through the fence to get the items, and then they came out. We normally don't have the cameras pointed into the yard because, like I said, they're sensitive to triggers. And every time a train moves, they'll set the camera off. We're just eating up, batteries.
Yeah.
So we usually have it pointed directly into the entrance of the yard. Because if they're going into the yard and they come out with stuff,
Yeah.
then, they broke into a container, because where else did they get it from? So, of course, the evidence of the containers that were broken into that we had to reseal as well.
Officer Vaughn, were there any items stolen the following day, July 5th?
July 5th, it was some items. So these items were taken on different days. So July 5th was another day of that it happened, because it was like a 3-day thing. The first time we didn't get them. Second day we ended up, I believe we caught some people, and then and maybe it was on the following day that also were items. It was like a 3-day thing that they were doing, because they were playing cat and mouse for a minute till we finally ended up catching some people. So on the 5th, we had some vehicles that were abandoned, and we had perpetrators running everywhere. And then we had at least maybe 2 vehicles abandoned at the scene. I ended up taking one subject down who tried to circle back and come back for his vehicle. And then another one of my fellow agents called another guy. So of course, you know, we had the white pickup truck out there. And the keys were left inside of it and the cell phones were left in it too. So
Let's talk about that white pickup truck. Where was that, I guess, in relation to the Huxley property? How was it positioned, or where was it parked?
it was parked lined up where the hole in the fence was. So it was in the pavement parking lot area of the pencil factory lofts, but it was parked in the position where if you come out of the hole, you can just throw something inside of the back of the truck. It was just lined up like that. So
Was the white truck one of the vehicles that was abandoned there? That's how you knew there was a cell phone in it and the keys?
yes, yes.
Is that the same one that activity in states that period? Number 3.
Okay, gotcha. Officer Vaughn, I believe it states Exhibit 1. Can you show that? And then we'll publish that on Zoom. What does that depict?
So it is in evidence, so why don't you publish it so that we can all look at it and you can ask them about it? And you should have, it'll come up on your screen, so you'll be able to see it better in just a sec. We'll all be looking at the same thing.
There we go. So Officer Vaughn, is this the hole in the fence that you were referencing during your testimony?
Yes, that is a hole in the fence. It is. And if you're going in, that's the hole going into the yard. You see those strip of lights at the bottom?
You should be able to, if you tap the screen once, and then just touch it, it's not going, then in the lower left-hand corner, there's a circle with a pencil in it. There you go, tap that. All right, now your finger can draw on the screen. So if there's something you want to highlight, just draw it.
Okay. Well.
And is there a way to make that picture any bigger? It's mostly not picture on the screen.
Well, but yeah, so this is like going, I believe, going into the yard from the pencil factory lofts.
So the picture is taken from pencil factory loft side? Or
this, I think the parking lot is like back here. It's like from the pencil, it's from the inside of the yard going out.
Okay.
Oh, okay. 200? Maybe we scroll up to 2. Yeah. There we go.
Because all that debris and stuff you see, that's inside of the yard area. So it's from the inside going out.
But those look like, what are the things with the reflector strips? Are those?
No, those are just, I guess that's just part of the pencil factory lofts.
Okay.
Right there.
All right.
I'm looking at from the inside of the yard. Well, but.
It's a confusing picture because it looks like the lofts in the background.
It does.
But it looks like containers between where you're standing and the lofts.
Okay, I see now. So this part, because I have more pictures, but this is the pencil factory lofts. The parking lot is a little further back because you got to climb over like a little type of wall just to get over there. And then you walk through there and then you can see the containers here.
Right, with the reflectors on the side.
Yeah, they have, so those are the cars.
Okay.
The cars are the flat metal where the containers sit on top of them.
Okay.
They have like the strip reflectors on there.
Yeah.
So if I was going into the Holsey yard, I would have to walk here first. But this part where you see all that dust and dirt, that's part of railroad property too.
Okay.
Because we own it all the way up to where their parking lot is.
Okay.
Because it's 50 feet from the track all the way back. We have 50 feet on both sides.
Got it.
So.
But this shows the whole.
The hole that they go in, that they go into right there. So,
okay.
And you see how big it is.
It's large.
Yeah.
Um, yeah. And Judge, has not been tendered yet, but I would like to ask the officer to identify this photo.
So do you have a hard copy of it? So
I don't have a hard copy of this one.
you don't, it can be all right if she puts it up on the screen and we all see it. If you object to it, in fact, I won't look at the screen while she puts it up. I'm gonna look at something else. And if he can lay a foundation, then we'll admit a digital version of what will this be, state 6?
Yes, Judge.
Okay,
All right.
all right.
That's fine.
Thank you, Mr. Glenn.
All items, because there are a number of items.
Okay.
It's 127 photos, Judge. So.
Are we going through all 127?
No,
Okay,
probably not more than 10.
okay.
Sure.
Did you put it up on the, I don't want to see it
I'm just gonna
until
walk
it's
it to
admitted.
him. I'll show Defendant.
Oh, if you got it just on.
And then we'll do it
Perfect.
this way. Do you recognize this photo?
I do.
Judge, I am showing Officer Vaughn with his state exhibit number 6. I'm asking him to identify what this photo is. What is this photo, Officer Vaughn?
It's a photo of, the subject coming out of the yard with 2 tires in his hand. Those are the same tires that was loaded into the pickup truck. It's the same type of tires.
Does this photo seem to be in the strict correct form as you shared with the state? Does it seem like anything has been changed or modified on the picture?
Nope, it's the same kind.
How are you familiar with this photo?
Well, I was the one that set the cameras up, and I was the one that pulled the photos from the video and submitted it into evidence.com.
So you're able to identify the footage. You're not necessarily saying, hey, the person in that picture is Steve Jones or Michael Smith. It's just you can lay the foundation that came from the camera you set up, and you're the one who pulled the footage from the camera and then developed a still from it. Okay, I understand that. Mr. Glenn, any objection? You've had a chance to look at 6?
Yes, briefly.
Okay, you want to look at it less than briefly?
Officer Vaughn, was that still photo taken from video footage from the date of this incident?
Yes.
The dates of this incident?
Well, yes, it should have a date on there, but it's during one of the dates that when these burglaries took place.
Judge, I would like to move to admit State's Exhibit number 6 into evidence and publish it.
Any objection to its admission, Mr. Glenn?
Objections as to the admission of the evidence itself. I would like to have an opportunity to cross-examine the witness with regards to it. In looking at it, there was, I didn't see a date stamp on it and other items that would have linked this photo to the date that in question that we're talking about. So in that regard, I don't think that I don't object to the fact that there was video footage there and that the officers testified that he set up those cameras, but in terms of whether it was it was video footage of the date in question that they're saying this event occurred, I do object.
Okay. Well, I think we're steering clear of identifying who was in that picture. Do you want to ask any questions, Ms. Davis, to shore up that this image comes from video footage of the dates we've been talking about, July 4 and 5? Again, I haven't looked at it. It sounds like for whatever reason, there's no timestamp on that one, or it was hidden.
Officer Vaughn, do you see a timestamp on this photo?
Yes.
What is the timestamp?
July 4th, 2023 at $5,500.
And is it your understanding that this photo captured the events on that date?
Yeah, so that was the 4th when the tires were taken. I remember on the 5th is when we made our arrest because they didn't get a chance to get anything because we was on top. We were waiting. And all hell broke loose. Everybody took off running. They didn't get a chance to steal anything, but they abandoned a lot of their cars. And we were able to make some arrests at that point. So we were set up and wait on them then. But the 3rd and the 4th is when a lot of the theft took place, particularly on the 4th, those tires were taken then. So, yeah.
Judge, the witness has testified that the photo does identify the date in question as one of the incident dates. And so with that clarity, I would ask that this be published and moved into evidence.
Okay, I'll do it in reverse order. I'll admit state 6, and then if you want to publish it, you're free to do that.
Thank you, Judge. And so Officer Vaughn, when this photo is published, I'm going to ask you to describe what we're looking at. So if you could describe what this photo is and how it relates to your investigation.
So those are the tires that were taken. If I had my report here, I can tell you which container it came out of. But those are the tires, or some of the tires that were taken from one of the containers that were sitting in a Halsey yard.
And is that a photo of the entrance and I guess exit where the suspects entered Husley property?
He is exiting the Halsey yard and making his way over to the truck where the tires were. So he's making his way out of the hole in the fence. And if you look at the video, you can see subjects going in and out, and they're carrying items constantly. The other 2 subjects that we arrested, they're carrying boxes, and they're also assisting with tires, but there are other subjects that are involved in this as well. It's just the ones we were able to recognize with, particularly Mr. Lemons is, we kind of know him in a cargo theft community, but those are definitely the same tires that were loaded into his white pickup truck.
Okay.
You look at the truck, it's just stacked with tires. So it's thousands and thousands of dollars worth of tires in that truck.
Anyway, the one that looks like he's got a lot of tires. Officer Vaughn, I'm going to show you another exhibit.
It's already been admitted, right?
Yeah, it's already been admitted. I believe this is State's Exhibit 3. Officer Vaughn, can you correct me? You have a physical copy of this photo. What number is at the bottom of that photo?
I believe it's a S3 or SAM3.
Thank you. This is what's marked as State's Exhibit number 3. Can you please describe what we're looking at here? What is this photo of?
You're looking at the white pickup truck that's leaving they're leaving the area and heading out towards the street. And this just loaded down with the tires that came out of the CSX railroad containers.
And this vehicle is exiting what property? Is this the pencil factory?
Yes, it's leaving the pencil factory, a loft area, heading towards the street.
And on the date that you attempted to catch the suspects, was this one of the vehicles that was left abandoned?
It was abandoned with the keys in it. I mean, it had not just the car keys, but a whole set of keys. And also had 2 cell phones in it as well. So.
Can you show the tag? Okay.
We did run a tag on it. So.
Officer Vaughn, I believe we're showing you was marked as State's Exhibit number 4. I believe that is the tag to the vehicle. Can you describe how you were able to identify who that vehicle belonged to?
Well, I think it came back to Shanika Dunn, and we know that either that's Mr. Lemon's common law girlfriend or his wife. We dealt with her before. And also.
When you say you dealt with her before, and I don't want to get into hearsay and this and that, but that she has been arrested in connection with cargo theft, or because you've already alluded to the fact that you're familiar with Mr. Lemons, her name has come up because she's linked to him?
Her name has come up, she's linked to him, but also these vehicles are usually in her name.
Okay.
And that's how we know her. I've never met her.
Got it. But in particular, this tag, which corresponds to this white Chevrolet pickup, is a registration in Ms. Dunn's name.
When I say I dealt with her, I've talked to her over the phone, and she gave me some wild story about why the vehicle was there.
Okay.
I actually tried to say it was stolen. Someone had stolen and drove it to that location.
Okay.
I tried to report it stolen the day that we were inbound.
Okay.
So that's why I say I've dealt with her before. But the thing that connected, I'm able to talk about how I connected it to Mr. Lemons.
Well,
That's
let's
where
just
I'm going.
go to the next, let's go to the next question.
Okay, so you locate this truck, the keys are still in the ignition. You said, what else did you locate inside the vehicle?
Well, we located, it was 2 cell phones inside the vehicle.
And were you able to obtain a search warrant for those cell phones?
Yes.
And what did you come to find out about the ownership of the cell phones?
The ownership came back to Mr. Lemons and Shanika Dunn. So it was both of their phones was inside his vehicle. And I was able to discover that from my cell phone warrant information.
Okay. Let me see if that's what. I think that's one of them. It's like, yeah. Mr. Vaughn, I believe I'm showing you what's been marked as State's Exhibit 5. This is a photo, I guess, at the fence. Can you identify who is in this photo?
Well, the man up front, that's going to be Mr. Lemons. With his hat turned backwards, and they're walking into the yard with some other subjects. The subject, well, there's a subject behind him, the one I arrested for trying to make his way back to the vehicle. And of course, the other subject is there too. So those 2 subjects were arrested.
So everyone else is behind the person who you're saying is Mr. Lemons. Can you put an X or something on the one who you said you ultimately arrested?
Arrested. Okay, hold on for a second. See.
Did you break it?
Here we go. Okay. So I arrested this subject here. I also arrested this subject here.
Oh, okay.
And those 2 were arrested. They were out there the same night that Mr. Lemons was. And this is Mr. Lemons right here. So.
Show the comparison photos.
Yeah, you can't tell them how it's getting, they didn't make a comparison.
Now, Officer Vaughn, how did you, I guess, identify Mr. Lemons from this video or still footage to the Mr. Lemons who you took out a warrant for?
Well, we pulled him up on his Facebook profile and matched him to his picture. Of course, there were other Norfolk Southern Railroad agents and also some GBI agents are very familiar with Mr. Lemons. And they shared photos of him as well. So we knew what he looked like. And we knew his name. We just never had an opportunity to meet him because he was kind of all over doing other stuff. But when we caught him on video surveillance, we was like, hey, this is our guy. And we were able to confirm that. We also got some very clear, nice photos from his Facebook and matched his body's type, his face and his whole figure up with these photos here. Yeah.
I know it. I'm showing what's been marked as, can you tell me what the bottom, I'm sorry, of that photo that you have before you, what's
state exhibit number is this?
That's gonna be S5.
Okay. And is this, did you put this photo together? Or did a colleague at CSX put this photo line up together?
One of my colleagues put it together. She actually sent me the, yeah, one of my partner put this together. She did. But she used my video surveillance cutout and do it. So, but she actually went on his Facebook and found these photos and put them together. And you see his body type is exactly like the subject here inside the video. So.
And so based on the video footage and the photos that you were able to pull from Facebook, is it your belief that Mr. Lemons was there on that property that day?
My strong belief that he was there on the property that day. Not to mention, you know, his cell phones and his vehicle being there, because he's the only one that drive that thing. Other agents and also other cargo theft units describe his vehicle at sites where burglaries have happened. So we know that vehicle. I knew the vehicle before, you know, that I saw it on my video, because we had bolos on it. And then when I finally saw it in my video surveillance, I recognized that what it was.
And on your surveillance footage, did you observe Mr. Lemons with any tools to assist with burglarizing the property? Was Mr. Lemons one of the individuals with any tools?
I believe I saw him with tools. There were other subjects carrying tools that night. So I didn't necessarily see him in the video surveillance with tools, but there are other, if you look at the other video, there are other subjects carrying tools as well. Usually they'll have just one person with the tool and everybody else is just kind of, because you only need one person to climb up there and cut it. And then everybody else pitch in and they participate in offloading the container. So anybody could be carrying it that night. So.
Because he said the vehicle was registered to female. You want to ask him if he observed the female.
And there were several people, I guess, that were either identified as participants with this burglary. Were any of those individuals a female?
No, there was one we thought was a female, but they're not a female.
I just wanted to clarify with regard to the registration that Ms. Dunn was not there on the property.
Okay, but I want to make sure I understand your answer. Meaning there was someone that CSX special agents took into custody thinking you're female, but then they did more investigation and determined not female? Or
no,
we saw footage of someone and on the camera that looked like a female, but that person got away?
We saw someone that we thought, because it looked like they had breasts, but they didn't. They were just kind of overweight. And we matched it with another subject with the same hairstyle and the same body. And we determined that that person was that person and not female at all.
Was that someone who ultimately was arrested in connection with these Halsey Yard thefts?
They are on the list. They hadn't been arrested yet.
Okay.
But no females that we know were there.
Okay. Is there any other information that you want to share that led to the arrest of Mr. Lemons for the burglary that occurred there on that property?
Just basically, you know, us seeing him on the video footage, recognizing him. Like I said, he's no stranger to the cargo theft community. We all work together. Norfolk Southern, also the GBI cargo theft, other cargo theft entities work together. And like I said, I've never I never knew him until they brought him to my attention, because we had meetings about Mr. Lemons and the type of vehicle he drove, because he was tearing Norfolk Southern up, and they told us about it. So when we finally had an opportunity to see this vehicle on our surveillance cameras, we knew what we had and what we were looking at. And when we saw him on video surveillance and we recognized him there, and we knew he was out there in the yard participating with these burglaries, and then his truck was loaded with those tires, and he can be seen carrying tires through the whole defense. Not to mention that vehicle with the cell phones in it, he's the only one that was driving that vehicle that night because his cell phone was there. Shanika wasn't there. And she really never participates, but she always calls and say, hey, you know, my vehicle. We had another situation where I impounded the vehicle.
For the record, I mean, his testimony is going way beyond what the question asked was. Of course, I can cross-examine with regards to that, but he's providing a lot of details about, you know, something that's not even an allegation.
Okay. Why don't you go to your next question?
Okay. Did CSX ever recover any property from the stolen items?
We did not recover any of that the property that was taken. Not as of yet, no.
And just for clarity, were there tires taken?
Yes, lots.
Were there microwaves taken?
Yes.
What type of microwaves were they? Were they commercial grade?
They were commercial, they were range microwaves, the ones that go on top of your stove. So they wasn't like the little microwaves you put popcorn in. These are ones that go on top of your range. So they're range microwaves.
Nothing further, Your Honor.
You shared a number of pictures of the white pickup truck with the tag that comes back to Ms. Dunn. That was one of the abandoned vehicles. When it was abandoned, did it have a bunch of tires in the back, or one of your photos has the truck not moving but stationary and it's piled high with tires? Is that a photo taken the night you arrested people and the truck was abandoned?
No, the night we made the arrest, they didn't get an opportunity to take a lot of anything. They just busted up a lot of containers, but before they started loading up, we intercepted that and we were able to disrupt that at the time. Now,
so the white pickup truck that was abandoned with the 2 cell phones and the keys in it, it had not yet been loaded up with merchandise.
no, but it participated in all 3 of the incidents that took place, and we got video surveillance showing it was there.
Okay. Got it. Mr. Glenn, your turn with this witness.
Thank you, Your Honor.
You're welcome.
Number of items covered, Your Honor. I may bounce around a little bit, but really just want to.
Any order you want to do it, your witness.
Okay. Thank you. Officer, did you all attempt to use, do you use facial enhancement or facial recognition equipment or technology?
No, we don't use that at CSX.
So if you get a grainy photo of someone, is basically what your interpretation is as to whether it depicts who you think it is depicting.
Yeah, the problem with facial recognition, it still has its issues, particularly recognizing African Americans. So we don't necessarily use that. People who we are familiar with, and we see them in our videos and photos, we can recognize them from that.
I mean, it's from your testimony. I mean, it appears that Mr. Lemon was someone that you all that you felt you knew, even though you hadn't met him or seen him personally. Is that right?
Well, when someone is engaged in activity, and we law enforcement share information with each other, so that's how we became familiar with Mr. Lemons, is through sharing of information of other law enforcement agencies that give information to us, because we are a carrier. We do carry goods and services like other agencies do. So they do share that information with us.
And I imagine those law enforcement officers said, okay, you showed them the video footage. And they immediately, I guess, pretty soon after said that must be Tyson Lemon. Is that right?
No,
How did that go down?
What do you mean?
When you said you shared information with other agencies, officers?
They shared information about Tyson Lemons with us. They showed us photos of him. They showed us pictures of his truck and other burglaries that took place that he participated in. So we had knowledge of Mr. Lemons, that he was a burglar. He do drive a white truck, and he drives a white pickup truck, and this is what he does. So we had that information, knowledge of that already. Then when we finally had an opportunity to experience him, then we knew it was him based off the information we received. And when we saw him on the video, we knew that was him at that point.
Did any of these officers ever arrest Mr. Lemon for all these other incidents that you're talking about?
I believe he was arrested maybe in Douglasville for something. I'm not sure. I know some of them were working on, have cases, open cases on them that they're working on with him. So.
Did officers tell you that they actually saw Mr. Lemon or saw photos of Mr. Lemon going into containers?
They have their own information, their own cases on them, is what I'm saying. So I don't know, I'm not going to say and talk about the details of another agency's case. I just know what we have on them, but the information they gave us is what they gave us. You know, they have their own cases with Mr. Lemons that they are currently working on at this point. So I don't know the full details of their case. They just share information that, hey, we have a subject that's doing this and that, and this is his vehicle, and this is what he likes to do, and this is how he, his method of operation. Okay.
Did you see any of these individuals that you arrested that night going into the containers? Did you have any video footage or pictures of individuals going into the containers that you all are contending were burglarized that night?
We do not have video or pictures of subjects going into the containers.
What about coming out of the containers?
We don't have them coming out of the containers neither.
What about touching the containers?
We don't have them touching the containers.
What about touching any of the items that were stolen?
Yes, we do have them coming out of the hole in the fence, holding the items and carrying them out from our yard to the parking lot of 350 Decatur Street.
You actually have that footage?
Yes, we do. We have video footage.
And pictures.
And pictures too.
Any of those were depicted Mr. Tyson doing that? Mr.
Yes.
Lemon doing that?
Tyson. Yeah, we have pictures of Mr. Lemons as he was entering the yard, and then we have another picture of him carrying those tires out.
So your contention is that that individual carrying those tires was Mr. Lemon?
Yes, that was the same tires that was inside of his truck.
Okay, so did you recover those particular tires from?
We didn't recover those tires. We know from our consist what the type of tires they were. And also inside the container, there was more tires in there of the same tires that were taken out. There's a large void of tires inside that container where those tires were taken out of.
How do you know that that individual, whoever that individual was who was taking tires out through the fence, that they were the same tires that were taken from this container?
Well, I would have to ask, where did they get them from?
Right.
So you don't get to ask him questions. You got to answer whatever the questions are. It's all right.
Well, sir, those tires, there were new tires. They came out of a container. They're nowhere else those tires could have come from other than our containers. When we have containers that are burglarized, the containers themselves, they don't take everything out of the containers. Some items are still there. That's how we know what the items were. So we go back to the container, and the container's listed in a report. And even pictures of the container with the tires in it to show you that there are some of those tires still left in there. When that train arrived, that container was full. The seals were not interrupted. After the burglary, the seals were cut, doors were open, tires missing. We have a large void, tires missing out of that container. That train was parked there that night, same night. Your client was out there and the other subjects were out there. And we see him coming through a hole in the fence carrying those tires.
So there was no objective way for you to determine that those tires that whoever that individual was carrying out, that they were the same tires that were taken from the container?
I can tell you there's.
So no, and then you can explain.
Say it again. Is it you?
I said that there's no way for you to, or you do not have any evidence which objectively identifies those tires as being tires taken from that container. Those particular tires being taken from that container. Or that individual took those tires from that particular container. No.
There was only.
Don't interrupt them. Let them finish, then you'll get to answer.
Fingerprints or identifying markings. I mean, that's, they're, from what I could tell from the video, there were no markings on the tires or anything. There's no objective evidence to tell you that those tires came from that container. Is that right?
The information we have is the tires, the container that the tires were in. That was the only container that had tires that was parked at that location.
Where did you get that information?
The information come from the consist. It's a list of what's inside those containers. We know what's inside these containers because we have a consist of what's inside of them, or what's being transported. Sometimes they'll say freights of all kinds. Sometimes they'll say tires or any type of merchandise goods. We know what's inside them. When we go into a yard and there are open containers and we look inside the container and there are items in the containers that have been taken out, there's something created called a void. A void is basically how items are stacked into a container. They're stacked a certain way, almost like wall to wall. When items are taken, there's a void. That means that it's no longer wall to wall. There's a large section that's just missing. And that's how we know that something was taken. I can tell you that the tires that were there in the yard were the only tires that were there. And seeing them come out with those tires, that had to be those tires because they're missing. We don't know where they're at other than what we saw inside that truck leaving on the video.
So we don't have to go around and around. It sounds like, and the way I'm feeling it, but there'll be argument. It's a circumstantial case.
Yes.
There's a container, I'm making the numbers up, that should have 500 tires in it.
Yeah.
And ultimately, that container has a broken lock and there are now 400 tires in it. And we see a white pickup truck that has a bunch of tires stacked on top and individuals carrying tires. But to your point, Mr. Glenn, because the surveillance cameras are pointed at the fence and outward, in other words, towards non-CSX property, we don't see the actual going into the container. But there is a circumstantial case of where else would the tires come from? And so I get that. And yeah, right, that's the photo I'm talking about.
Yeah, but these tires have.
Why don't we put that up on the screen? What exhibit is that?
That exhibit S3.
States 3. I was going to ask about that because the tires have these white squares on them.
Those are labels on brand new, only brand new tires have those type of labels.
You don't drive with white squares on your tires?
Well, yeah, so you see those labels? Those are they're the same labels those tires had were inside the container. So we knew they were new tires because they were inside the container, a picture of the tires inside the container with the same white labels on them.
Okay. So I think we're all saying the same thing. There are dots that can be connected. And then the question is the strength of that connection enough to be a preponderance of the evidence or not? But Mr. Glenn, I'm hearing you real clearly. The CSX does not possess video of people going into a container, in particular video of Mr. Lemons going into a container.
Exactly. I mean, I'll move on.
Okay.
That's it. Officer, did you see Mr. Lemon? You said there were a number of individuals that you arrested or that were arrested that night.
Yes.
And it sounded like you actually saw individuals running who you you thought were involved in this, fleeing, is that right? Is that?
Yes, sir. Mhm. Yes.
How many people did you arrest that night?
I believe that night we arrested 2 that night.
And you were there, were you actually on, you were actually on the scene?
I was there. I arrested one of the subjects. I was there.
These are the people, you had one photo where you were saying Mr. Lemons was walking in the front and there were 2 people behind him. And you said the 2 people behind him were, I guess it would be the 2. I didn't have a sense of how many were arrested, but they would have to be the 2 who were arrested that night.
Right.
There's our picture. So,
okay, so this subject right here was arrested on a, try that little thing again. Okay. Here we go. So this subject right here was arrested on a warrant. This subject was arrested at the scene. So these subjects were there the same night.
it's not showing up on our screen. Did it show up on yours, the little color?
Yeah, I did. So what's that?
Hold on, maybe it's just real slow. I don't know. Nope.
Okay. So
anyway, there are 2 people behind the person who you say is Mr. Lemons. There's one to the right. Who is the warrant? The one to the right or the one to the left?
Furthest back.
Furthest back was picked up later on a warrant.
On a warrant.
Okay. Oh, it went away. And then the one who was slightly closer was arrested that night.
That subject tried to come back, double back to his vehicle, and I arrested him then.
Okay, and that's not the white pickup truck that the person tried to come back to, but a different
It was
car.
a different vehicle. It was a Chevy Blazer, I believe.
Okay.
Did you see, did you identify, let's be specific, did you identify Mr. Lemon, actually driving that vehicle at any time, getting out of the vehicle, driving the vehicle?
No, we couldn't see who was driving the vehicle. The camera image wasn't close enough where we can actually see inside the vehicle.
So for the purpose of this hearing, as evidence, you are not here to testify. You're not saying that Mr. Lemon was driving that vehicle with those tires in it, right?
I'm not saying that. I'm simply saying he was there when it happened and participated. But we don't know. Like I said, I can't prove that he was actually driving the vehicle. It's his vehicle. We can't. There's no video evidence of that.
Can you put states, I think it was 3, back up? A timeline question, then I'll.
The other 51 with the 2 individuals.
Yeah, the one with the 3 people walking near the hole in the fence. Whatever number that is. Is that states 3 or 2? It says S2?
S2.
Okay, so we're clear for the record. We're putting states 2 back up. Was this film made the same night as the picture of the white pickup truck driving away with those tires with the white labels on them?
No.
Different night.
That's a different night. That is the last night that they were out there, that we got them that last night. The 4th is, I believe, when the tires were taken, and I believe maybe the 3rd is when the microwaves were taken. So
this picture is the night that actually the second person in that line of people was arrested.
Yes.
That night. So Mr. Lemons, you were claiming this is Mr. Lemons in the front with the backwards baseball cap.
He was out there. He just got away.
He got away, but not in his truck or his girlfriend's truck.
No, we were on top of them too fast, and we were at their trucks, and they couldn't get to it because they had to come through us first.
Okay, so this footage is night of arrest for some, not the night of the picture of the white pickup truck driving away with all those tires on it.
No, I believe that pickup truck night of the tires was, I believe that was the 4th.
Okay.
4th of July.
Thank you.
Yeah.
So you did make an arrest. You said you arrested 2 and 3 individuals at one of those nights. We're talking about 3 nights now, right?
Yeah, we did make an arrest.
Okay. And one of those folks arrested was Cortez Wise, is that right?
Yes.
Okay, and did you participate in the interview with Cortez Wise?
I did.
And, I'd like to That actually was a interview, it's about a 15-minute interview. I think it'll be, well, it will be informative, I think, and certainly I would defer a good portion of my continued cross-examination to that video. It was video 3. We could have that.
It's something that you received in discovery from the state?
Yes, yes, it is something that I did receive in discovery.
Okay. Ms. Davis, do you have any objection to making the Cortez Wise, can we spell his last name?
I think it's W-I-S-E.
Standard spelling. Mr. Wise's interview with CSX special agents as part of the record in this case?
No objection, Judge. I will say that it is just an audio. It is not really a video.
Okay, it's whatever, as long as it's what Mr. Glenn received. And you're saying it's not, we're not going to be here for 4 hours listening to this?
No.
Okay. So you would like to tender that, it sounds like there's no objection, and then you'd like to publish it. We'll call this Defense 1, and that will be Mr. Wise's interview. And before you play it, just so I have better setting, with whom is Mr. Wise speaking?
He's talking to me.
Just you?
Yes, and also my agent Kane as well. So.
And that's a partner of yours?
Yes.
And where is this interview happening?
This happens at the Zone 3 precinct.
As in Atlanta Police?
Yes.
Okay. It's the night of the 5th. So we just had that picture up, states 2, and it's that night.
Yes.
Okay.
And Mr. Wise was, he actually admitted that he was there at the scene on the date in question, and that he was able to observe certain things surrounding this particular incident.
Yes.
Otherwise, witness of certain actions and individuals that night. Actions of individuals that night.
Yes.
Okay. Whenever you're ready, make sure you click that little box in that when you're sharing. There's a little box on the share screen that says share audio. Then it ought to be pretty audible.
Okay, today is July the 6th, 2023, and the time is?
It is 1:52.
Time is 1:52, and I'm here with Agent Bennett Kane, CSX Rural Police, myself, Agent Vaughn with the CSX Rural Police, and Atlanta Police Officer Canales. And we have
Cortez. Cortez.
Cortez?
Yes.
Say your full name, Cortez.
Cortez Wise.
Cortez Wise. So this is an investigation into a burglary on CSX Road property. Okay, Cortez, go ahead and just tell me basically what happened tonight. Just start from the time what you did and before you got out there, and the time what you did when you got to where you, the location.
Sitting in the woods. Just watching out. I was just watching out.
How'd you get over there?
I had caught the bus.
You caught the bus over there? Behind 349 D49 Decatur Street. You caught the bus.
I got off at the train station right there.
So how'd you know to go over there? Who you meeting with over there?
Some boy named T. They call him T. That's what I know about T.
A guy named T.
Yeah.
And a meeting with T. So, I mean, how did all this start? How did you know to even go over there? So was it somebody called you? And what did they say to you on the phone when they called you?
Now he like, I just need you to watch out. And then,
watch out for what?
Did he call you today or text you to that?
No, he didn't text me. He had, they did a 3-way on the phone. It was a 3-way call.
So who's on the phone on the 3-way?
Vunt.
Vunt?
Yeah.
What's his name? Real name?
I know about Vunt.
Okay. What did he drive?
Like a black Charger.
Okay, so Vaughn, you, and who's on the other line?
T.
T. So who told you to meet?
Vaughn and T done told me to come up there.
Vaughn and T told you to come up there. And what did they say?
They said they need me to watch out because they finna get them some money.
Did they say how? They gonna get some money?
They didn't say all that. They just say goddamn it's sweet and this and this and this. That's what they said.
They said it was sweet?
Yeah.
Okay. So when you met up at that location on the bus, was Vaughn and T out there?
I ain't see them right now there.
Who'd you see out there?
There wasn't nobody right there. I was right there by myself. Then when I walked down from the bus stop and then I walked back there, I ain't see nobody till like I said about 5-10 minutes. Then there was 5 guys come in. I don't know them guys. I just knew Vaughn and T. That was it.
Were they there?
They were there.
So what does Vaughn look like?
Kind of brown skin.
What kind?
I don't look at nobody about it.
And what about T? What does he look like?
I'm back.
Okay.
Vaughn is light skinned, like red, and T is brown skinned, darker than me.
And they're always together?
Yeah.
What kind of hair?
One of them, they got little hair. The other one is.
Did that.
He always get the hat on.
He said it was 5 guys. And it was supposed to be called there, so he did call up every 6
So these guys pretty much asked what? You met them before? You say you hadn't met them before?
Who you talking about?
Vaughn T. Vaughn T. You hang out with Vaughn T on the
No, I
regular?
don't hang out with them on the regular. I work at the cemetery. Right down Lincoln.
Would you know Vaughn T if you saw him? Okay, I'm getting ready to show you 2 driver's licenses that I have. I'm going to show them to you. I've taken pictures with them on my phone. With Vaughn T.
Look for me at that. Vaughn.
That's Vaughn?
I don't know that one.
You said there's a light-skinned dude out there.
He want that ain't him.
Okay, but I look like Vaughn?
That's him.
That's Vaughn?
Yeah.
Okay, so Vaughn is going to be Jarice Marquise Simon Talbot, nicknamed Vaughn. Okay, and you said you don't know the other subject, Lee Antonio Manley Jr.?
Okay.
Okay. Oh, you don't recognize him?
I ain't never, you always keep the hands on his face.
Keep what on his face?
Mask.
Okay, alright. Okay. Okay. Tell me about Vaughn. If Vaughn was there, is Vaughn driving?
I ain't see all that. I just came out there.
So
I came out by like 12.
Tell me what happened when y'all got there. Tell me what happened. When you got there, you, Vaughn, T, y'all all together, some other guys. Tell me what, let's start from there. What happened?
Okay, they were popping locks, and I was still in the wood.
You say popping locks, what does that mean?
Like the container locks.
And how do they do it?
With cutters.
With bolt cutters?
Yeah.
Okay. Alright. So, they popping locks. Where were you when they were doing that?
Yeah.
Okay. After they popped the locks, what happened? Did they get anything off?
That's when they said you were coming in.
They saw me in the truck.
Yes.
Okay. So they saw me in the truck, and then what happened when they
took off?
They took off.
Yes, sir.
Okay. But before then, they did get some stuff. Before that happened, did they get anything off the containers?
I don't know, because I had came out at 12. That's when you came in. That's when I was a white guy, and then when I saw the gray truck coming.
T, Vaughn, and you were the lookout, so you saw me. You let them know I was coming.
No, I didn't, because they already saw your truck. They said they were being chased by you once before.
Really?
Yeah. I think over there on Pier or something like that.
Wasn't me.
They said it was a truck like that on Pier chasing that gray truck like that. They said y'all got new Fords.
Okay, makes sense. All right, so UT, Vaughn were out there, and do you recognize any of the other guys that was out there?
No, sir.
The subject that we have, that was locked up with you, do you know him?
Not like that.
How do you know him?
It was childhood. Like, he
What's
watched
his
me grow up.
nickname? What's his?
I didn't know about Joe.
Joe?
Yeah.
Okay. And y'all grew up together, so?
No, we didn't grow up together. He just used to come through, ride through, and, you know.
So how long? I mean, this is the first time you've been out there this week?
Yeah, this is my first time.
You went out there the night before?
No, sir.
Okay. What about Joe? Was he out there the night before? Was this his first time?
I don't know. It probably was his first time. I don't know. I don't know who came out yesterday.
So who organized all that? Who organized everything?
I don't know. I ain't gonna lie to you. It probably was
Vaughn?
Yeah.
Y'all scared of him? Shaking your head, is that yes or no?
No, I ain't scared of him, but the people is though.
He what?
I said people is scared of him though.
Why do they fear him? Tell me, why do they fear him? I'm saying, I'm asking you, why would they fear Vaughn? He's a man, why would they fear him? Has he done something to cause people to be fearful of him?
Yeah.
Like what?
A lot of things. A lot of things.
Has he killed somebody? Beaten somebody? Threatened somebody? What makes him a fearful guy?
I don't know if he killed nobody, but how he talked, it seemed like he did. I need a cigarette.
I don't smoke.
Does.
Huh?
I
Yeah, if he can get a cigarette, or maybe Dave has one. Yeah,
I got a vape.
Huh?
I can smoke my vape.
You ain't supposed to have that. But
No,
I guess you smoke it until now.
It ain't no, it's nicotine.
Huh? Are they allowed to have those at the jail? You can use it. You can go ahead and smoke. You can go ahead and use that. You can use that. There you go. But we'll have to take that once you.
I know.
Okay. Is there anything else you want to tell us?
Man, I wish I ain't going to jail, man. I show you what I know where to start at.
What spot?
Where they rent, where they finna go to.
Where are they finna go?
Close by. Man,
Who?
Close by.
What does that mean?
Like round the way. You look up the tag.
Huh?
You look up the tag on that white truck, you'll see.
That's where they're taking everything?
I see.
Okay. Who owns that white truck?
I don't know. I can't tell you that. I don't know if I what. I don't know.
Does that Vaughn truck?
It probably is. He the only one moving around.
Does he drive that truck all the time?
It don't be that truck. It'd be a blue truck. But he always keep the truck. So it might be
He drive U-Hauls too?
I ain't never seen him drive no U-Haul. He probably have, man. This my first time.
Well, I heard he has a moving company.
This my first time.
First time dealing with him?
No, first time doing this period.
Well, I'm saying, they said Vaughn has a moving company, so he do have U-Haul trucks. He do drive them.
Probably so. I ain't never seen him in. I always seen him in trucks like that or something like that.
Okay. But it's your first night being out there, right?
Nah, this my first time ever doing that period.
Okay.
Just watching.
So you went out there a couple of nights before?
No, sir.
When they stole some tires?
No, sir. I'm not gonna even lie to you. I'm telling you everything the truth. Everything the truth.
Okay. All right. Anything else?
What else you want to know?
Well,
Can you show us their phone numbers out of your phone? Vaughn and T?
They don't have. I can show one phone number, but that's the only number I got.
is that the number that Vaughn called you from?
It'd be a private. I mean, and then it's a private number.
Okay.
So Agent Kane's gonna get your phone. You can show us the number that Bonk called you from. Can you do that?
Yes.
Okay. We're looking through Mr. Wise's phone at this time, trying to find Bonk's phone number.
I don't know the code, but I know the.
You don't really look for your phone?
Nah, my girl did, but I had my fingerprint on it.
Show that to Agent Kane, please.
Was that bottom one?
No, it was just the top.
You got that? You got it. Okay. Anything else?
No, sir.
All right. Agent Kane, you have anything you want to add or say?
Does T have a facial hair? Does he have like a beard or anything like that?
I mean, yes, man.
Like the,
Faded beard, yeah.
does he have like a mustache?
Putting it all around.
Yes, sir.
That's T? And you don't know T's name?
No. We just call him T.
Okay. Well, T's one subject's been identified as T. So, and he hangs out with Bonk all the time.
I don't know, man. It's my first time out here today. I just.
All right. We'll stop here. We're going to stop the interview at this time.
All right, Mr. Glenn, do you have questions for Special Agent Vaughn based on that?
Yes, Special Agent Vaughn, did you show this individual any photographs of Tyson Lemon?
I don't believe we had photographs of Tyson Lemons available at the time. What we did show him was a driver license, two driver licenses that we recovered. Those are two individuals we were trying to identify that was inside of a U-Haul truck, but I don't believe we showed any other.
Who were those two individuals?
One of them was Jerice, and I can't think of it. Bailey might have been the other subject. So
I'm sorry, the other one was.
So I think Anton Bailey or something. I can't think of his name right now, but it's two driver licenses inside of a U-Haul truck. One of them was a guy I got a warrant for that was in the that can be seen with Mr. Lemons in the back. The one I got a warrant for, and then the other subject we can't find him.
So did this individual ever indicate to you that Tyson Lemons?
When we're talking about individual, we're talking about Mr. Wise?
Yes, I'm sorry,
Okay.
Mr. Wise. Yes, Your Honor. That Mr. Wise, did he identify Tyson Lemons to you as a person who was there?
Well, he claimed he didn't know any names. He just gave nicknames. So, I mean, he said that was his first time doing it. he didn't really know nobody. He was just trying to make some money. So I don't think we brought Mr. Lemons up or his photo up to Wise for him to identify.
It sounds like the two photos you showed were actually driver's licenses that were recovered from some U-Haul you're talking about.
Yeah, that was at the scene.
Oh, it was on the 5th.
Yeah.
That was one of the abandoned vehicles.
The abandoned U-Haul there, and we recovered a wallet that had 2 driving licenses. One of them was definitely Jerice, and the other one was a friend of his, a buddy of his. But Jerice was arrested later on a warrant. He's also in the video stealing stuff too.
And is he in the indictment in this case?
He is.
Okay.
He's in there.
Right.
Yeah. So, but we didn't ask him about, we was only asking him about the immediate individuals that we had, the one we arrested, the one, and the 2 people in the driver's license.
But you asked him, did you ask him about everybody who was involved, or just the ones who were arrested?
Just if he could remember anybody or give us any additional information, and you can see that he really wasn't, and he was afraid to identify some other person he wouldn't mention. So we were going to push.
Is that right?
Yeah, that Vaughn guy, and that guy was Jerice. So he was kind of scared to even talk about that, but he did identify Jerice from a driver's license and said that Jerice was out there. But
So just to summarize, what evidence are you presenting to this court which identifies Tyson Lemon as the person who was there at those yards committing, as you say, theft from cargo containers?
his image showing up on our video and video surveillance, his truck being out there, his cell phones being out there abandoned along with car keys. I had house keys and everything else on it. And also him being on video the night of the thefts that was taking place. So the only thing is he just eluded us that night. But, you know, we later, when we put everything together and put all our evidence and videos together and also determined that that vehicle was related to him, had belonging to his girlfriend, they both share residence together, then that's what evidence we have on him.
And have you, and I guess just to cap everything, of all the items that were alleged to have taken or that were identified as being taken from any and all of these containers, were any of them ever traced to Mr. Lemons in terms of him being in possession of them, in terms of him, you know, moving them to other individuals,
Oh, we can say,
people, other places?
you can say Mr. Lemon's truck moved the items. And we believe he was driving that truck. Like you heard in the interview that Mr. Wise said, he mentioned the white truck. It's the same white truck that we all discussing now. If he said, if you run the address, it'll come back to where the stuff was. And that's going to be Shanika's Dunn address.
But there were no search warrants done at that address to see if microwaves, fans, or tires were there.
There was not. There was some information that was passed to us that apparently Mr. Lemons has a business, kind of a warehouse somewhere, maybe in Forest Park. They might have been keeping those items in. I believe that some other agencies were working on a warrant for that. So.
And that information wasn't followed up on?
No, was not followed up on. We didn't believe that the items were there at Shanika Dunn's house. We just didn't believe that they would actually bring those to that house, that they were actually taken somewhere where they could be fenced off. That's just, well, most cases in our experience, most subjects don't bring their stuff home, take it somewhere else. another location. So,
And you said search warrants were, you acquired search warrants for the phones?
yes, yes, sir.
Did you get any, was there any, communications, dialogue, I mean, any kind of information ascertained from those phones?
There was nothing useful for our case that we could see on there, just some general stuff. So we believe he had more than one phone. Like most people do involved, they have multiple phones. That particular phone that we recovered didn't have anything useful on it, but we do believe he might have had a second phone. So that possibly may have been the phone that he used, but the phone that we recovered just had general information, just conversations between him and his spouse and just other stuff, but nothing that we could use. But we used that phone to determine that it actually belonged to Mr. Tyson Lemons, and the other phone belonged to his spouse. And they both were together inside. Those phones were together, recovered, along with the car keys abandoned inside that vehicle.
Did you even determine whether service had been provided for those phones?
Yes,
Or
there
was
was.
currently being provided for
Yes,
those
there was
phones?
current service, and the service providers were the ones that posted the information on the warrants. You can see the service provider and the person who owns the phone information. Everything is on the search warrant. You can see it. So you see the service provider, the owner of the phone. One phone belongs to Shanika, the other phone belongs to Mr. Tyson Lemons.
What about location information in terms of movement of those phones?
No.
None of that?
No. Like I said, there was nothing useful on there that we could use other than identifying who the phones belong to.
That's all I have, yeah.
Any redirect, Ms. Davis?
Just a couple of questions, very briefly. I just wanted to clarify about how items are stored on Husley yards. Are tires, for example, stored outside of the containers, or are they stored inside of the containers?
No, so the Halsey yard is not a storage yard, like per se. You have like the Halsey, the Fairburn Intermodal yard. If if you haven't been out there, if you ever want to go see it, you can. But the Fairburn Intermodal yard is it's like a small city. It's large. They have actually containers stored at that location. Inside those containers are goods. Customers come in, they pick their containers up and they leave. The Halsey yard is more of a storage yard for trains that can't fit into the Fairburn yard because it's too many trains. It's like, think about how airplanes are. And you see airplanes sitting in the sky, they can't land because they don't have any clearance yet. So you're talking about a 4,000 or 5,000 foot train needs clearance in order to get into a yard. So while they're waiting for another train to move so they can pull in, they sit at the Halsey yard. And they may sit there probably all night, may sit up there for a few hours, just depends when they can get clearance to move.
And is it your recollection that there weren't any tires sitting outside of the railroad cars?
No,
Nice and question.
there's no tires, nothing stored there. Everything is an actual train that's in transit. That's in commercial transit. That's the only thing that's out there is trains in commercial transit. They have engines attached to them and everything. They're not cut cars or they're not storage containers. They're actual trains that are in transit.
And did you rely solely on that one video still image or the videos of Mr. Lemons to identify him and tie him to this incident?
Yes, that and also his pickup truck as well.
Were there anything else that tied him to the scene for you?
Just like I said, the videos, the phones, and the pickup truck has tied us to it. So
And do you see Mr. Lemons here in court?
I do.
Can you please identify him?
Yes, he's in a blue jumpsuit, white t-shirt.
Judge, I ask that the record reflect that Agent Vaughn has identified the defendant.
He has.
Nothing further, Judge.
Mr. Glenn, anything else with this witness?
No, other than the fact that, I would ask again in response to the redirect that you did not, there's nothing on the video, no evidence of anyone observing Mr. Lemons driving that white truck.
No, not that, I'm sorry.
Didn't see him.
Right, sir. Yes.
It's not depicted on any video that you're saying that you're testifying to.
Yes.
Today.
Yes, yes, sir.
No further questions.
All right. Special Agent Vaughn, appreciate you being here.
All right.
You should leave those exhibits right there.
All right.
Ms. Davis, do you have any other witnesses?
No, Your Honor, just argument.
Okay. Do you plan on presenting any evidence beyond the exhibit that you tendered in the cross-examination, Mr. Glenn?
No, yeah.
All right, then the evidence is closed and I am ready to hear from both sides. Ms. Davis, I'll have you go first, and then if you want to say anything briefly in rebuttal after you've heard from Mr. Glenn, I'll give you a chance to do that. You don't, you may want to, but you don't have to. If you have trains to catch or search or whatever, you should go do that. All right.
Thank you, Agent Vaughn. I appreciate you. Okay. Judge, as you are aware, the standard in a probation revocation hearing is just the preponderance of evidence, which is our lower standard of evidence. It's not beyond a reasonable doubt, just more likely than not that the defendant did commit the offense as alleged. Mr. Lemons is charged with burglary in the second degree. I just want to point the court's attention that burglary in the second degree is when an individual without authority and with intent to commit a felony or theft therein enters or remains within an occupied, unoccupied, vacant building, structure, or railroad car. And that is exactly what we have here. We have Mr. Lemons that was shown on photo evidence being on the property. We have a truck that is, although registered to his significant other's name, we have his cell phone located within that truck. That truck came to the property without tires and then left with tires. Then that truck returned again multiple days until CSX caught on by installing cameras and catching them before they could act. We did hear testimony from Defense Exhibit 1, the audio from Mr. Wise, who said that they were, quote, popping locks on the property. So on that date, while we did not observe any tires in the white truck, we did hear from a participant in this scheme that they were popping locks on that date, the date that we saw Mr. Lemons on video entering the property. We also heard testimony from Agent Vaughn, who said that he did observe Mr. Lemons carry tires from the property. He did observe the individuals leaving through the pencil factory and taking those tires off the property. Not just tires, but microwaves as well. And so I would ask, based on the totality of the testimony that we heard, the photo evidence, and the auditory evidence, that Mr. Lemons, more likely than not, participated in a scheme to remove items to commit a theft on the property of Huxley Yards, which is located within Fulton County. He did enter that property to commit a theft, and I would argue that a theft did occur, but at a minimum, he did commit burglary in the second degree.
All right, thank you. Mr. Glenn, response.
Yes, John. In response, I contend that the evidence clearly establishes that there is no evidence that Mr. Lemons entered any container, took any items from the container, committed any of the acts which are necessary to prove a burglary in the second degree. Being in a location which we contend he was not, and which we think the evidence does not support because there's not clear and convincing evidence that he was even there, given the fact that their sole evidence is grainy video with his picture attached to the grainy video with the clear idea that they wanted to identify or have identified the person in the grainy video depicted as Mr. Lemon. But beyond that point, there's no evidence that I heard which indicated that anybody observed outside of this grainy video, Mr. Lemon's there at the scene. And we contend that the video is not Mr. Lemon. It doesn't depict that it is. There's not been any kind of recognition, enhancement, equipment, which would give us a clearer indication as to who, in fact, that individual was. It's all based on Joan eyesight. He talked about consistency with body type, and I saw quite a number of pounds difference between the Mr. Lemons and the person depicted in that video. And I think for all those reasons, Jana, and I don't think we need to stretch and surmise, even though we don't have any evidence that he ever touched the items stolen, what those items actually were outside of reports that certain things were taken, which would have tied Mr. Lemons to this particular incident. I think that there was a clear indication from the testimony that they felt Mr. Lemons was a potential suspect, a prospect for burglarizing, most or all of the containers that had occurred in that area, but he had not been arrested for that, not been accused of that, and not been any evidence presented here in court today that he had done any of those things that the agent contended that he had done. For those reasons, John, I don't think that state's met its burden of proof.
All right, thank you. Ms. Davis, anything else?
No, Your Honor.
All right, so Mr. Lemons, as I tried to describe at the beginning of our session, the state's burden here is a meaningful one, and it's the state's burden. Mr. Glenn doesn't need to prove anything. You didn't have a burden, didn't need to call any witnesses, et cetera. But it is not the appropriately heavy burden if this were a jury trial for the actual second-degree burglary charges. It is just the preponderance burden. So is it more likely than not? And what I find the record that was made today shows is that a truck associated with you, not in your name, but associated with you, on one of the nights before that truck was left abandoned with your cell phone in it, that truck was used to drive from the edge of the Halsey yard a truckload of tires taken from a container. I think that there is more than adequate circumstantial evidence that a container was broken into that had a bunch of brand new high-end tires, and those tires made their way into the back of the white pickup truck that's associated with you. Mr. Glenn is right. We don't have what would be, I guess we'd call it like the smoking gun of here are people climbing into the container and getting the tires. But we don't need all those pieces for a preponderance of the evidence. Empty pickup truck, full container. Half hour later, or however long it would have been on the surveillance video, full pickup truck, partially empty container. And we can all connect those dots using reasonable inferences. And I do find by a preponderance that on whether it was the 3rd or the 4th of July, that white pickup truck was used as the getaway vehicle for many, many, many tires that were taken out of a container from the Halsey yard. Then we know either the next night or the night after, again, I can't remember if it was the 3rd or the 4th, where the images show the pickup truck associated with you full of the tires driving away. But so the next night or the night after, there is footage that Special Agent Vaughn identifies being you and two others. I agree with Mr. Glenn that that is grainy footage. Special Agent Vaughn is entitled to his informed opinion as to who it is, but I don't base my ruling solely on Special Agent Vaughn's conclusion that that's you in that one picture that shows three people walking towards the big hole in the fence. But what we do have, uncontroverted proof, is that same night that has the footage of potentially you and someone who was arrested there that night. So we know that other person was there, and a guy who has a warrant out for him. The truck associated with you in your girlfriend, common law wife's name is left at the scene. And in that truck is your cell phone and Ms. Dunn's cell phone as well. That abandoned truck ties that day of flight and the arrest of some co-conspirators to the preceding evening where tires were taken and a burglary clearly was completed. And I find that it sufficiently connects you to the phone, to the truck, to those series of events that circumstantially the state has met its burden that you were a co-conspirator in the second-degree burglaries that occurred with the tires. I don't find the state met its burden as to the microwaves. I didn't see any microwaves, don't know where they went, didn't see them in the back of the white truck that is connected with your residence and Ms. Dunn and your cell phone. Same with the fans, but I don't need to find that. I find that the state did sufficiently connect you to your property and property associated with you that was inextricably intertwined with the actual theft or burglary of those tires. And so I do find that the state has met its burden and that you did violate the terms and conditions of your probation when on or about July 4th of 2023, you are a participant in a scheme that resulted in a series of second-degree burglaries on the Halsey shipping yard property of CSX here in Fulton County. So with that, we need to talk about what are we going to do? Ms. Davis, what is the state's recommendation in terms of Mr. Lemons and revocation?
Judge, our recommendation is now in line with probation's recommendation, which is to suspend the balance. I believe Mr. Lemons has 3 years, 5 months, and 17 days on probation. And we would ask that that entire balance be revoked and close his case out.
Close out the 14 SC case?
Yes.
Okay. Mr. Glenn, what is your recommendation as to what happens with the revocation?
Well, Your Honor, with regards to the punishment for the revocation that the courts found, we request and we respectfully ask for leniency in this particular instance. I realize that incarceration is something that, we've heard the state's recommendation for incarceration. I would request that the court consider leniency in that regard and impose an incarceration sentence of 18 months, which would be roughly half of what would be involved, which has been recommended by the state. I think that Your Honor is aware of the fact that Mr. Lemon has exercised a lot of effort in attempting to rehabilitate himself from other challenges that he's had and that he's well aware of, that he put the work in to do that.
Sure. I worked with him for 2 cycles of many months in our accountability courts. And I agree 100% that there were times when he took his recovery very seriously.
Yeah, and even with regards to probation. I spoke to his probation officer on an occasion and recently, actually, and he had indicated that Mr. Lemon, even though there is some fine involved, that he was paying fines, but that he was, as he indicated to me, that he thought he was doing well, that he was reporting, and that was, I guess, some follow up with his progress. So in that regard, I would, for all those reasons, I would respectfully ask that the court exercise leniency and impose something less than 18 months.
Okay.
Than what the state has asked for.
All right. Mr. Lemons, of course, this is your revocation, not mine or Mr. Glenn's or Ms. Davis's. Is there anything you want to add, or has your lawyer spoken sufficiently for you? Okay. You got to make that light green. It was green. Tap that little. There you go. Good.
Yes. McBurney, I dealt with you, like you were saying, and, since I, been out on the street, I ain't been in no trouble or nothing, Since I got out of drug court, I've been on probation. I ain't had no problems, no type of problems on probation. I've been doing what I've supposed to been doing. And, with the payments now since Douglas County, they combined with Fulton County. So when I send money, it goes to Douglas County too. So, that's what, I guess the little mistake was coming in at, the reason why I was slacking on paying. But, I always have been engaged with probation to try to get off of it, So, like I say, I'm a family member gone passed away, my little cousin, since I've been in jail. My little girl, she graduated, Tatiana. So,
Where'd she graduate from? From high school?
Yes.
Okay. And what's she going to do?
She's thinking about being a judge.
Being a judge. So she's going to college.
Yes.
Okay. Does she know where she's going?
Nah, she ain't figured out yet because her grandmama, she's a judge in Douglas County. So.
Okay.
Other than that, I've been doing what I'm supposed to do. I don't lost my shop since I've been locked up. So, somebody stole one of my race cars, we talked about that, so.
Right. I know those were precious to you.
I just been trying to just do right, since I've been out, and I reported to the probation and they locked me up. So.
Well, it sounds like they had this waiting for you.
Yeah.
Well, Mr. Lemons, I'm not concerned about the financial piece. Clearly, money has been a challenge for you for a while. In fact, I didn't receive any evidence about whether you were arrear, meaning behind in fines or fees. I'm gonna fix that anyway. This has never been about the money. It's been about this hustle you had and the consequences that's had for CSX and Norfolk Southern. And you sound a little bit, I want to be clear, my decision that I made was based on, it wasn't a lot, but it was enough evidence to connect you by a preponderance of the evidence to what was going on at the CSX yard, the Halsey yard, just those 3 days. You listened to Special Agent Vaughn and you're kind of the Billy the Kid out there. Like, oh, he ran Norfolk Southern ragged and then he turned to CSX. And that may well have been a pretty serious side business you had. I hope it's coming to an end, but my focus was just on what the state was able to prove up. Your truck, your phone, kind of hard to walk away from that. And we don't need to have a back and forth about it. It's sort of like leaving your fingerprints there, but you left your truck prints and your phone prints and your key prints. And that truck kept coming back there, 3 days in a row. So what I'm going to do is revoke 2 years of your probation. You'll get credit for the time you've been in. I'm closing out the probation and I'm doing whatever the verb is called to cancel the fines and fees so that when Mr. Lemons is released from completing this revocation, whenever it is you get paroled out or they close it out, this case is closed. The 14 SC case is closed. You're not going to owe anything. And I'm going to encourage you and Mr. Glenn to speak. Today we won't do it, but just so you know, if you end up resolving your other case, it's probably going to be the same sentence because it's a meaningful sentence for a property crime. And I don't mean to minimize property crimes, but you weren't breaking into people's houses and making them feel violated. It was a commercial burglary, still a loss to CSX, to those customers of theirs who had the microwaves and the fans and the tires and any other instances with which you might have been involved. But one, this is old stuff. It happened 2 years ago. And two, I know from working with you that you seem to have turned some corners. And I hope someday you'll stay moving in that direction. But there are consequences for having been mixed up in the things you were. And it sounds like you might have been more of a leader than a follower in that process, which is another reason I'm taking this particularly seriously. So it's a 2-year revocation. I will close out or terminate the remainder of probation in that 14 SC case. And Mr. Glenn, my recollection is you are counsel of record in the new case, which is this, it just has a new indictment number on it.
Yeah.
Last thing I'd ask, I know there was business swirling in Douglas County, not because Special Agent Vaughn referenced it, but it shows me he knows something about your client. I remember meeting you during drug court because Mr. Lemons was having to work with a, dare I say, even Rico. It was something swirling in Douglas. What's the status of that?
It is, that has been resolved.
Oh, good.
There was, in fact, there was some probation imposed, no incarceration. There was a no plea that was accepted. And you know, so there was no admission. Now, again, there was some evidentiary concerns that we worked through over in Douglas.
Got it. He always gets away without leaving his fingerprints. So the only remaining matter you're aware of in the metro area would be the indicted version of what we just heard about from Special Agent Vaughn.
Yes.
Okay. Well, I feel like I'm familiar enough with that. I know there's some moving parts because there are a bunch of defendants. Some of them have feigned ignorance about what the case is even about. I remember when they came in, like, I don't even know why I'm here. And they and their lawyers will work through that as they choose to. But I am very open if you and Ms. Davis talk in the coming weeks to say, maybe we should just wrap all of this up in light of the findings I made here. But that's merely a suggestion. You will give Mr. Lemons the wise counsel that you always do, and we'll see how it flows. Okay?
That's been the discussion. And
okay.
I certainly concur with you know, that should close everything out. I think we'll be able to.
Okay. Well, that'll be easier to do sooner than if and when Mr. Lemons is transferred out. We can always get him on Zoom and do it that way, but time will be a little bit of the essence on this one. Okay.
Yeah.
All right. Well, I appreciate everyone's time, and it sounds like I'll see some of you soon. Thank you.
Thank you, Judge.
Oh my gosh. Anyway, I know you're part of the police.